Read into the record a public disclaimer, and then followed by calling the roll.
Okay. Notice of the March 11th, 2020 meeting of the Real Estate Commission, including date, time, and location, has been noticed on the Tennessee Real Estate website since October 30th, 2019. Additionally, this month's agenda has been posted on the website since Friday, March 6, 2020. Okay, for the roll. Commissioner Joe Begley.
Here.
Commissioner Jeff Diaz. Vice Chair Marcia Franks.
Here.
Commissioner Steve Gwynn.
Here.
Commissioner John Moffitt.
Here.
Commissioner Stacey Torbett.
Here.
Commissioner Bobby Wood.
Here.
Chairman John Grease.
Here.
You have a quorum.
Thank you very much, Ms. Maxwell. I'm going to ask at this time for Commissioner Bobby Wood to lead us in an invocation, and then following that, if you'll all stand, he'll also lead us in the pledge to the flag. Mr. Wood.
Please bow with me. Our most gracious Heavenly Father, we just thank you so much for being here today. We just see all the things that have gone on, especially weather-wise here in our state, and just we're just thankful being able to be here, and just things like that happen just to remind us that we're not in control, that you are, and we just thank for all the little miracles that have happened that have allowed so many people, especially in my community, to be able to make it through the storms, and just ask your guidance over our meeting today. Ask in your name. Amen.
Please stand.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Bobby. Let's talk about the news for a minute. We'll get to Real Estate Commission business in a second. So, Bobby, you were kind of in the heart of this tornado last week. How's your community doing? What's happening out there? And you're from Mount Juliet.
I'm from Mount Juliet, and so I'm actually I live about 3 miles from what happened, but it literally kind of came right down the interstate, and I was just telling Steve. The number of trees that's lost allows you to see all the real damage that happened, and the tornadoes. If you don't learn anything about them, they're not fair. I mean, they will come through and they'll destroy a strip. I mean, all the way down to the foundation, and then other things that. You're like, how in the world is it standing together and it's still there, and maybe lose a couple shingles? But we've had all kinds of stories of people that made it to their closet or wherever just in time before their house literally blew apart around them. And but it's been amazing. I think the people that probably are the big unsung heroes right now have been our police. And I've seen it in Metro. I've also seen it in our area, Mount Juliet and Wilson County. I mean, it was like a orchestrated play. I mean, they did such a great job of getting out, moving traffic, blocking things, doing what needed to be done. They did a great job, and what could have been, I mean, it was horrible, but it could have been a bigger mess if they hadn't been so good. And there's if you ever look on Facebook and stuff, I know like the Mount Juliet police, they were wearing their cameras, and it showed, I mean, right after the storm happened, they were literally going door to door rescuing people. I mean, there's a lot of people that got trapped because their house fell in on them, and they were going house to house and getting people, rescuing them out of their basements and stuff. So it's pretty miraculous that we didn't have any more loss of life than we did. And it's one of those things too, the number of schools that got tore up. I know where our kids went to school, Donaldson Christian, they literally lost the elementary wing. They had a portable that got picked up and just bounced down the elementary wing, and the chassis for the trailer is still laying on top of the building. So you take that, and then we lost West Wilson Middle, which is our middle school in Mount Juliet. We lost Stoner Creek Elementary. Both of them will be torn down. And then Mount Juliet First Baptist and their Mount Juliet Christian Academy got some damage. I mean, you think about if this happened in the middle of the day when kids are there, we would have had hundreds of kids hurt or worse. So it was a miracle it happened when it did in the middle of the night.
I'm glad your family's safe.
We're good.
That's
We're
good. John Moffett, did it get close to you? Did it impact you?
It was about 2 miles from me, so I was lucky.
Damage?
No damage. We didn't have electricity for 3 days and no cell service.
Really? Well, that's kind of nice, I guess. All right, the second topic has to do with this beer virus. What's it called? Coronavirus. And I suspect Ms. Marcia Franks is in the heart of the problem in the state of Tennessee. What's new down there, Marcia, in Franklin?
Well, Williamson County has 4 cases. Our schools are closed. My grandson goes to BGA where there's been 2 of the cases. That school is closed. They're actually going to have classes, online classes, until further notice. A lot of panicking going on down there. A lot of people buying a lot of toilet paper and water. Just a lot of fear going on, I think, caused mainly by the media. But everybody's really frightened by it. But I just believe I would rather live in freedom than live in fear. So that's how I'm going to live my life. But it's a lot of fear.
And Joe, you've got a case up in your neighborhood. How's your neighborhood feeling? What do they do?
They just announced it on my trip here, so
Okay.
I think they'll be fine. A lot of people buying toilet paper.
No fear in Upper East Tennessee?
No.
All right, and finally, before we get started, I want to introduce, for the record, our newest commission member, Steve Gwynn from Memphis. And Steve, if you'd like to, you can say anything about yourself so that people know what you do or what you like, or you can say pass.
Nothing. Okay. Just a quick background. I moved to Memphis in 1987. I was with Trammell Crow Company, which is a large real estate developer in Texas, and we moved to Memphis in '87. I've been there ever since. And my career essentially has been with Trammell Crow, and in 2004, I joined Highwoods Properties and ran the Memphis office until the end of last year, effectively. And Highwoods made a decision to leave the Memphis market and sell all of their buildings, which was about 1.8 million square feet. And so it was a big deal. And that's all happening right now. So I was on the board for 2 years, the Memphis Area Association of Realtors in 2009 and 2008. So I've been involved locally with our board for a good number of years and been president of the Commercial Council. We have a separate group underneath MAR, which is about 325 brokers. So I have 3 grown children, 2 of which don't live in Memphis or even in the state of Tennessee. So
What
5
is it?
grandchildren. That's it. Okay.
That's the important part.
Yes.
Thank you, Steve. We're glad you're with us.
Sure.
Finally, before we get to the agenda, John Spear is here, who's like the head counsel for the Department of Commerce and Insurance. John, anything you came to talk about, or you just want to see us?
Glad to be here, glad to see all you fine folks. Oh, but I know.
What?
Better not in comparison to Steve, but she's wonderful too. I worked with her on the Memphis Symphony Board for a number of years. She was
Correct.
work in that fine place to be educated. Appreciate all of your work, your commitment, your service to the citizens of the state, and as general counsel, we are here to help you succeed in the work that you do, and we're always available. And I'm fortunate that always.
Thanks for stopping by. All right, with that all handled, we next need to approve today's agenda. Is there a motion to approve the agenda as presented? Let's get that motion on the
I'll
floor.
make a motion.
Second.
Okay, the motion is to approve the agenda as submitted. Ms. Franks.
I would like to add to the agenda, I guess under Executive Director's discussion, licensing requirements. And then I'd also like to add under the Executive Director too, the license search for principal brokers. That's all.
Anyone else? All right, the motion on the floor is to accept the agenda as presented. Ms. Franks made an offer to amend it twice. Is there any objection to those those additions? If not, the chair will assume we have a motion to accept the agenda with the two additions Ms. Franks added. I'd like to talk about this myself for a minute. So we've asked council to send something up to the Attorney General regarding who can pay a licensee. Has that left yet? Has that left this building and gone to the next building?
No, not yet.
Would it be possible that we could look at it before it goes, just to make sure that?
So we're working on, we wanted to provide you with an opinion, our opinion as well. And if you then disagree with that opinion, we'll of course submit it to the AG's office, but we are preparing something to present to you all in April.
Oh, let's say this commission says we still want the AG's opinion. Can we see the document that goes to him? It's got to be in writing, I suspect, right?
Right, so I don't think that would be an issue.
Okay, thanks. That's all I had on that. All right, let's vote on today's agenda. Those in favor of the agenda as amended, please vote aye. Aye. Those opposed, no. That motion passes unanimously. All right, next is to approve last month's minutes.
Move to approve.
And I have a motion by Ms. Franks, seconded by Ms. Torbett. Any discussion? Those in favor of the motion to approve last month's agenda, vote aye. Aye. Those opposed, no. That motion passes unanimously. All right, next up are informal appearances. Is Ms. Gouge here? Deborah Gouge? Okay, don't get up yet. I just want to see who's here. Jacob Edwards? Okay, perfect. All right, to both couples, for lack of a better term, this is how this will work. We're going to start with Ms. Is it Gouge? Googe, thank you, sorry. We're going to ask you both, the licensee or the applicant and the broker, to come forward. Ms. Matlock will ask you to swear to tell the truth, and you have to decide whether you're going to or not. We hope you do. At which point, Ms. Maxwell will give us a brief synopsis of what you're doing here, okay? When she's finished, Ms. Gooch, we're going to let you tell us everything you want us to know. And that can be why you're here, how it happened, who you're with, what you've been doing since, where you go to church, whatever you want to do, you just tell us what you want us to hear. And then the commission will reserve the right to ask you questions. Following that, we're going to let your proposed principal broker tell us why he is interested in having you affiliate with his firm. And commission can ask him questions as well. And at the end of the discussion and question and answer period, we'll take a vote to see if you can move forward to get your license, okay? And that goes for you guys as well. You're second, okay? All right, now, if you two, Ms. Googe, come forward with your principal broker, Ms. Matlock will swear you in. All right, Ms. Maxwell.
Okay. Before you have applicant Deborah Googe and her principal broker, Dwayne Powell. Ms. Googe has taken the Tennessee Real Estate Affiliate Broker exam. The firm is Saxon Clark Enterprises, doing business as Weikart Realtors, Saxon Clark. The summary of the criminal and disciplinary sanction is a felony relating to wire fraud. The statement and letter of recommendations can be found on your iPad.
Okay. See how brief that was? So you've got all the time you need to tell us what happened and how you got in that position and what we need to know. You have to bend it forward to.
Bend it.
There you go.
Okay. I'll do my best.
Okay.
I got involved with someone that was an immigrant from a different country, and kind of convinced me that we needed to help immigrants. So that's what we started doing. Started filling out paperwork and helping some people, and we did help some people. And I guess the short end of the story is, I mean, I could go into specific detail, but it all ends up the same. He inadvertently sent money back to Israel without me knowing. Ended up, the feds show up at my door one day. I don't have a clue what's going on. Took me a while to figure it out. And the wire fraud basically is because I used a printer and a fax machine and a copier. That's what they said that was. There was some money that had went through his account, and they said that money was made from immigrants, which, you know. Anyway, I was given a choice, this or this, and the choices I was given, neither was really good, but I took the lesser of two evils, and I did my time. Never been in a situation like that before, so it was really hard. I got through that and come back home. I've been back home about a little over 5 years now, and started to rebuild my life. And I wanted to get back into something that I could kind of, I guess, justify myself for me more than anything else, to get my self-respect back for what the mistakes that I did. Decided I want to go to real estate school, met him there, and really think the world of him, and this is where I'm at. I had to wait this long from probation to be able to go, you know, and take my test and those things. And I apologize for my voice because I just had surgery yesterday, and they put a thing in my throat so I can't hardly get my voice out.
So anything else? We're going to ask you some questions, I'm pretty sure.
Okay.
So if you need water, let us know. We've got some back here. Would you like some?
Yeah, that would
Ms. Franks,
probably
you went and
help.
ask questions like this.
Okay. So what have you been doing since you were released from custody?
I've got a mother that's 83-year-old that I've been taking care of. She's very ill, and I am with the love of my life, actually, and just been rebuilding my life that way. I haven't worked or anything like that.
Okay. So how many counts
Thank
of
you.
wire fraud did you have?
Oh, I don't have that in front of me. I think they only charged me with the one, though.
I can help you with that.
Yeah,
You
I
had-
don't-
You had 24 counts of wire fraud. So this wasn't just a one-time, one thing that you did. That was 24 counts of wire fraud. What about concealing material facts? How many counts did you have on that?
I don't have it.
That
in
was
front
40 counts.
I think they were basing that on the amount of people, like each one, they were like,
Was
say if
harmed.
there was like 5 immigrants, they were doing like each one, I think is how that was.
And then the false income tax return, there were 42 of those, 42
They said-
counts.
They said that I did not file, that I did not claim the money that I took in on my income tax.
Vice Chair Franks, I'd just like to clarify, those are the count numbers, not the number of counts. So if you look on it, it's count 24 and count 40 and count 42. So those are just
Okay,
one
okay,
instance,
okay.
not 24.
All right, so what exactly did you do?
Basically just filled out paperwork for immigrants that were trying to get their, whichever paperwork they need, either work permits or green card or extensions, whatever they needed.
Were they legal immigrants or illegal immigrants?
Some were legal, some were not.
Okay, so you helped prepare the tax returns for them?
Yes, no, I'm sorry, not the tax returns. There was actually a tax person that they would go to for that. I had a couple of people that I knew that were CPAs, and I would refer them to them, and some went to those people and some didn't.
Okay, so what exactly was your part in it then?
Just filling out the paperwork for them.
Okay, if you all if it would be okay, I wanted to read something that I found in the News Sentinel newspaper when I Googled it. Is it okay if I
You have the floor.
read that? It says, a federal judge on Tuesday doled out the maximum sentence for an East Tennessee woman who conned illegal immigrants and their employers out of thousands of dollars by holding herself out as an immigration specialist. Greenville U.S. District Judge John Greer sentenced Deborah Gouge 53 to 57 months federal prison for a series of financial frauds, including scamming illegal immigrants and the Social Security Administration. It was the maximum sentence provided under the federal sentencing guidelines for her particular case. They also ordered her bodyguard to spend 27 months in prison before they deported him back to Israel. Assistant U.S. Attorney Helen Smith pushed for a maximum sentence for her. Deborah Lynn Gouge pursued a multiple-pronged criminal enterprise, which included the receipt of Social Security Administration disability benefits for which she was not qualified, the submission of false federal income tax returns to the Internal Revenue Service, and a fake immigration document scheme, which victimized and undocumented Hispanics who believed she would provide them with legal status in the United States and the opportunity to lawfully work. Along the way, she defrauded the Citizenship and Immigration Service so that her co-defendant could lawfully remain in the United States and travel freely between the United States and Israel. Meanwhile, Gouge, posing an immigration specialist, charged $3,000 for the promise of obtaining for illegal immigrants either citizenship or a work visa. In a plea agreement brokered between Smith and defense attorney Richard Talley, her bodyguard admitted he acted as Miss Gouge's bodyguard and billboard, lied to her illegal clients, and even threatened some with deportation if they complained. Last month, he tried to backpedal on whether he served as an armed muscle man for Gouge. Smith laid what she termed his inability to tell the truth at Gouge's feet as well. It says that you were ordered to pay more than $157,000 in restitution. So it seems like it was a little bit more than a one-time occurrence, and that you committed fraud. I have to tell you, as a real estate commissioner, that we're dealing with the biggest investment any person will ever have in buying a home. What have you done since that could reassure me that someone who hired a bodyguard to protect them and to shake down illegal immigrants for money, what has changed? And you said 2 or 3 years? What's changed, and how did you change?
Okay. In my defense, as I said earlier, I had two choices, and I had to take the less evil road. I did not hire a bodyguard. This is what you're reading is exactly what they put in the newspaper. I've read that ad as well. It's on the web. I'm not here to try to defend myself to say that I did or I didn't do this or that. What I did was I chose a certain path because my family was threatened. That's why I had only one choice to go. I did not hire a bodyguard. They just put that name tag on him. He was doing things behind my back that I was not aware of. If I would have been, I wouldn't have been involved in what I was involved in. Now, and when you say there's more than one instance, yes, there was, because there was more than one person that I did work for. There was no set $3,000 per person. They said that. I don't know where they came up with that. There was a lot of things that was thrown in there that I had no awareness of whatsoever. So when it was all put in a big pile, and in the end, I was given the choice, you either do 40 years or take a plea bargain. Well, what was I supposed to do? And I think anyone in my position would have done the same thing. Personally, I don't think justice was served. I think he should have fried for what he did. But he's back in Israel now, and that's all I know about that. He's not allowed to come to the States, thank God. And no, I haven't worked since I've been back for this reason. I've been trying to figure out what it is that I need to do with my life to go forward. And I'm almost 62 years old, and it's hard to start over, especially when something like this has happened. So it's been devastating to me and my family. I've tried to overcome the memory of it all. I'm reminded of it daily, as I just was, and it's hard. But as I said earlier, I want to prove not only to other people but to myself that I can overcome this, and that's why I'm here.
So how did you know this man that was involved with you?
Back in '89, me and my father, which he's passed now, started managing professional fighters, boxers. So his brother was a international fighter. We had 7 fighters, and that's how I met him. He was a brother, and that's how I met him.
So he wasn't related in any way to you?
I married the brother.
Oh, you were, so
Yeah,
this was
so
your
he
brother-in-law?
was like my brother-in-law, yeah.
This was your brother-in-law
But we
that was-
divorced, and he was like a kid, when I first met the brother. And he's not like his brother, that's all I can say. He was completely different. But I didn't know that until the end. I didn't realize. I was naive. Let my heart get in the way.
Got it, Steve. Go ahead.
Curious, out of all the professions in the country, how did you decide on real estate, which is a licensed profession? Why did you not look at some other profession that doesn't require a licensing procedure such as what we're talking about today?
Okay, I moved to Miami back in '83. My son died, and I just had to get away, so I moved to Miami and started a new life there and got into property management. So I was really good at it, and I've always kind of liked it. And then I got involved in the boxing, came back home. My dad got sick. I came back home. And then this all happened. So I liked it. I've always liked property and things like that. So I've managed several different properties through the years back. And now you have to have a license to do what I did back then. So that's why.
Other questions? So, Ms. Googe, let me ask,
Oh, okay.
that's okay. So, did you take other people's money?
Yes,
And did you not report that you took it?
I did.
You did report or you did not?
I did report, yes.
So, were there any income tax charges involved in anything that you agreed to? I mean, if you took the other people's money and you showed it as income to you on your income tax returns?
Oh, I see what you're saying. Yes, I did take people's money for, I traveled and did things and charged accordingly.
You didn't take it, you earned it. Is that what you're saying?
Yes, yeah.
Because it sounds like the charges are that you...
I know, that's how it sounds, but that's not how it was. Yeah. No, I charged accordingly. Like I said, I traveled. I'd have companies call me and ask if I could come and help their employees. And basically, we'd sit down like this, and I would, individually, each person, as they would tell me what they needed, if I could help them, I would, and if I couldn't, if I didn't understand it, then I couldn't do it. But the problem is with the other person, the co-defendant, he was not, okay, how do I explain? he was doing things behind my back that I wasn't aware of. He was going to people, he was taking money saying that he had come to collect from me. And I guess that's how he got all that money back to Israel. That's where he was getting the money. But in turn, we both got charged with it.
See, that's my concern. If you're taking other people's money, even if you don't know you're taking it, that's not good.
I didn't know.
I understand your comments, but I struggle with the idea because we deal with people's money in real estate every day. And it's just troublesome to me that you pled guilty to taking other people's money, basically.
I did do that.
And I see that as a problem for your broker and for you trying to establish a business when people can go on the line like Ms. Franks did and pull your name up just like that, which is what people do to real estate agents every day. And it's going to be problematic. I think Mr. Gwynn's question about why you chose real estate is a fair question for you to think about and for him to ask. All right, other questions for Ms. Googe?
I have a question.
Yes.
So you're saying, from everything I've gathered here today, you're saying you thought you ran a 100% legitimate business, and
Absolutely.
so you thought you were dealing with the right government officials on immigration, you were dealing with the right,
Yeah,
you were talking to,
Yeah, I went to Memphis several times to the immigration office. I mean, yeah.
what's the name of your business?
I'm sorry?
What was the name of your business?
I just named it DG Immigration Services.
Steve?
Did you have an office? I mean, did you lease an
No.
office? How did people come to?
Word of
your-
mouth.
I mean, were you operating out of your home or?
Yeah, I had an office set up in my
car or
home,
what?
but people would call me, and like I said, it's mostly employers. They would call me and say, I heard you help these people, can you come and help us? And I would go, it's mostly businesses. And I would go to their business and meet their employees and them and discuss.
The businesses were trying to get fake Social Security numbers? Is that basically what they were?
Oh, no, they were just trying to get work permits, extensions and things like that, or a lot of them had overstayed their visas, and you could file applications for that to renew them. So that's what it was.
And you held yourself out as a specialist in that area, right?
That was just something they named me with. I never ever said I was a specialist in
All right,
anything.
so what was your background? How did you know how to do it?
It's on the web. I mean, you can pull all the applications up. It's
So you
pretty
didn't work under someone before you started
No,
working
no,
for yourself?
No, I never did. But these people, they don't speak English. They don't write English. They don't understand. They're scared. They're scared they're going to be deported and things like that. And the business owners basically wanted to get their people legal to where they could start paying taxes. And a lot of these people did get tax ID numbers and start paying their taxes. So the employers started taking money out. So they did start paying taxes.
Other questions? All right, Mr. Powell, before you make comments, have you learned anything you didn't already know this morning? Okay, I just wanted to see. All right, why are you interested in having Ms. Googe as an affiliate? And if you'll move that microphone towards you, and you might have to just move the hand.
Ms. Googe came to me, I guess it's been roughly 2 years ago, and I'm a real estate instructor with pre-license. I own the real estate school in Kingsport. And we actually had this discussion prior to her sitting in on the course. And she did ask, would I be interested in taking her on at that time? Well, I didn't know her at the time, okay? But after she took the real estate course, she did have to wait out her probation period, and through that time, we had a very detailed conversation as to what she had done. I read the same article that you read as well. My research into it, based on our conversations, I found that Ms. Googe, to be honest with me and upfront, what I have found over a course of 2 years, and she's been in constant contact with me, she's got a good heart. She was actually trying to help some people and ended up getting thrown under the bus pretty much. You know, she was in a professional sporting type scenario, which, you know, we all know that, you know, things go on behind the scenes in sporting, especially boxing. And basically, from my understanding, the gentleman that she is referring to from Israel went back to Israel and cannot be extradited back to the country to face his charges. So basically, everything fell on her shoulders. But she has, I guess, proven to me that she wants to reestablish her life and come in with a career with a little dignity and respect.
All right, questions for Mr. Powell?
I have one other question. The article that I read said that the other gentleman served 27 months, and it says that she served 57 months. So they held you more accountable than they did him, obviously, right?
He actually didn't serve that time. He was here only 16 months, I think. The Israeli consulate came and got him and took him back to Israel. So he didn't have to serve all his time.
But do you have any idea why they gave you more time than him?
No idea.
Okay.
Go.
I am friends with the broker, Mr. Powell, and I'm going to abstain from this vote.
Mr. Powell, so it's really for both of you. I need to know what your plans would be for Ms. Gooch if she did affiliate with your firm. I'd say it's going to involve a significant amount of work, I suspect. And Ms. Gooch, I need to know, Mr. Wood and I share the same concern that we can say, if we did vote to let you get your license, that tomorrow you would leave Mr. Powell's firm and go somewhere else.
Can I answer that?
You feel free to.
This man right here, when I first went to his school and we talked, from day one, he has stood behind me and told me, be strong, this is what you need to do. And I've done everything that he's told me to do. I've done everything that you guys have told me that I needed to do. My loyalty is with him. There's 3 other companies that would hire me right now if I had my license. I've told them my loyalty is with Dwayne because of what he's stuck with me. And I wouldn't be much of a person if I didn't stick with him. I have no intention of going anywhere else.
Okay, Mr. Powell, back to you. How do you plan to supervise? How do you see her fitting into your company?
With my company, I'm actually licensed in 3 states, Tennessee, Virginia, and North Carolina. I have 47 agents that I oversee in the office. I have structured my office very well to where I keep up on all the paperwork that comes through, okay? So we do have the structure in the office to accommodate if anything gets out of sorts. I would, of course, know about it before it happened, okay? The reason I'd like to see Debbie come in to my firm, I mean, understand I've been a licensed broker 70%. I've been a principal broker 70% out of my career. So I've owned 3 other real estate offices, so I know I know everything that goes on in my office. I stay up on everything that goes on in my office. You know, my philosophy is integrity and professionalism in the marketplace. And I instill that not only in the school, but also in my office, okay? And like I said, Debbie has, we've had some pretty detailed talks about what went on, and I feel as though that she has turned her life around, and she just ended up in a very unusual circumstance, and she has served her time, and she went through her probation, and she has proven to me that she has actually tried to reestablish her life with a lot of integrity. I don't know if I answered your question, but
Many times I make my personal vote based on what I think about the broker, not the applicant. And
Yes,
that's so if there's anything else about you that I need to know or how you operate,
Could you tell us about your disciplinary sanction that you've had with Trek in the past?
Which one?
All of them.
As far as, I've had one complaint personally against me that was eliminated many years ago. I've had a few agents that's had some very minor complaints that never made it to you guys because there was no basis for it.
You were sanctioned, though, at on one occasion at least, though. You don't remember what that was for?
That was, if my memory serves me correctly, that's been, what, 10, 15 years ago? Is that the one you're referring to?
I just know you've had a disciplinary sanction. That's why I'm asking you.
Right. That one was just a situation where an individual was trying to take advantage of his mom and purchasing a house, and he threw all kinds of accusations out there, and it was reviewed by the Real Estate Commission, and that was, I was never found guilty on those charges because I didn't do anything.
So, Mrs. Matlock, would we have on here disciplinary sanction if he was found not guilty of something?
I'm not sure. I'm looking at the enforcement tab right now. So let me get right back to you.
While Ms. Matlock's looking at that, Mr. Powell, this is a somewhat unrelated question, okay, and it won't influence my decision, but you have a school that you operate as well?
Yes, sir. I have the real estate school in Kingsport. I've had it in operation since 2005. I've put several hundred people through that school out into the marketplace.
So is that a full-time job as well?
Yes. I do a principal broker by day and I teach by night.
I'm not even suggesting this, but we've had cases before where people seem to think that the school was basically a recruiting tool.
No, sir. I do not recruit out of my school. Absolutely not.
Just checking. Just want to make sure. Bobby?
I guess, as the time I've been on the commission, I try to look at what the applicants present to us, and then maybe what their testimony is when they come in. As I read the application that came in, I get the feeling, it's just kind of presented as, like what happened, and it's some wire fraud, and used the fax machine, printed off some forms, and sent them in, but this is a whole lot more than that. I don't think people get a prison term of 57 months over some faxing. I think there's a whole lot more to it, and it didn't really come to light until, Commissioner looked on the internet, and that's my concern. I'm just not so sure that you've been extremely as candid as I would preferred for it to be. And when we become a real estate agent, we have access to people's finances. We have access to their checkbook when they start writing earnest money. They're trusting us. Granted, they're supposed to read our contracts, but they don't. They trust us to guide them in the right direction. And we're able to stay in business as long as we keep that trust with them. These people did the exact same thing to you. They put their trust in you, and then ended up they can't trust you, and you end up having to serve time for that. And that's my concern of you getting into real estate. We could be right back dealing with this very same thing again, where they couldn't trust you and you took advantage of people. And that's my concern. And maybe there's other things that you might need to do other than real estate. So,
We'll make a motion.
I wanted to see what Anna said.
Okay.
So,
While we're
Ms.
waiting,
Tarver.
I haven't fully understood what the actual fraud was, because you were able to get visas or green cards for some people, correct? So where did the fraud charges come from? Like, what was the actual fraud?
Honestly, I'm not really sure.
Move up to the microphone, please.
A lot of what happened in court was what I would call hearsay. The prosecutor, she got up there and started saying all these things, and I'm looking at my lawyer saying, what is she talking about? I don't even know what she's talking about. They mentioned people's names I'd never heard of before. Immigrants' names I'd never heard of before. They had no witnesses. They had one person come and say that, well, he lied. He got up there and he said that we had guns. And then the judge asked him, said, you know, you need to tell the truth here. And then he's like, no, there was no guns. I mean, that's all they had. And it's like, no one was shocked. I thought I was going home that day. No one's more shocked than what I was, because I just really didn't, I just don't think that I did anything wrong. And I have a friend that is a retired FBI agent. Before I even started doing this type of work, I called him and asked him, am I legal to do this? And he said yes. And the things that I did, I felt I was doing legally. And like I spoke to one of you earlier, I went to Memphis with these people, to the immigration office, many times, sit in on their interviews, you know, and tried to explain, because they didn't speak English, you know, and there were people there to translate, but they wanted me to go, so I went with them. I tried to help as much as I could. So I wasn't hiding anything from anybody. I think, and I've had a long time to think about this, I think that what basically happened is Jawad, the co-defendant, was going behind my back, threatening people, collecting money, because he didn't work anywhere else. So he had all this money he was sending back to Israel that I found out in court about, that I didn't know about. So he had to be doing what they said. But evidently he told them it was under the direction of me, which is not true. So that's about the gist of what I know about it.
So your position is you didn't falsify documents? You didn't present
No, I never
false
falsified a
information?
document, never, ever. There's no way you can. I mean, it's black and white. It's name, address, you know, it's basic things. Those, you can look at those applications, they're basic. I mean, and all you do is you go by the person's passport and whatever ID that they can produce. And there's no way to falsify it.
So I have an update. We looked up Mr. Powell's information, and he does not have any disciplinary sanctions. Everything has been dismissed. There's no sanctions against the firm.
Okay. In the future, it would be great for us not to have that on that information on this sheet then, where it says disciplinary sanctions, yes, that would help us. I would just like to say this. I've got four problems. Number one, you don't even understand what you did. You don't, after 57 months in a jail, you did a plea deal, you had attorneys, and you still don't know what you did. Number two, you've shown no remorse. You've not said, I'm sorry, one time. Number three, you're not taking responsibility for what you did. You're blaming someone else. You didn't say, I'm sorry, I did it. Please give me another chance. And then number four is Mr. Powell said nothing about training. It was just watching. He said nothing about training. And so for those reasons, I'd like to make a motion that we do not accept your application.
All right, the motion's on the floor, if there is a second.
Second.
Seconded by Mr. Wood. Discussion on the motion. So, generally, the chair prefers that a positive motion be made, which we don't have to do at all, and we'll stick with the motion. So if this motion passes, then we're telling Ms. Googe that at this point, it's not appropriate time to get a license. So if you're in favor of that, and we'll note that Mr. Begley is recusing himself from this vote, you'll vote yes. And it'll take 4 votes for that motion to pass. Any discussion or questions or clarification before we get started? Once again, the motion is to deny this applicant's application. If you're in favor of that motion, please vote aye.
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 If you're opposed, vote no.
No.
Okay, so I've got 1, 2, 3, 4 ayes and 2 noes, so the motion passes. Ms. Gooch, I know you're disappointed. You can come back and see us, but if you'd like,
See, I'm getting the same thing here, and I'm not trying to be vengeful in no way, because that's not who I am, but I'm getting the same thing here as what I got in court. You're prejudging me, and you're wrong.
I think that would be a mischaracterization. Well, I think what you should take from this.
Well, what she was saying is that I show no remorse. Listen.
I think the vote has passed at this
I
time.
had all this time to sit and think about who I trusted, who I put my trust in, and who did me wrong. So, yeah, I take blame because I was too naive to see what was happening behind my back. Maybe I didn't want to see it. Maybe I did. I don't know. But that's neither here nor there. But I have done my time that they gave me. I have served and done and tried to come back, and I keep getting beat down every single time.
Ms. Gooch, I would like to say this. All of us up here took an oath to protect the public. That's all we're about here. It's not personal. I wish you well. I think there is a place that you can work that doesn't have a Tennessee license, and I wish you well. And I'm very sorry that we couldn't approve you.
I am too.
Y'all, thanks for coming down today. And be
We'll
careful.
need to do a fresh start analysis because we have denied licensure based upon a criminal conviction. So we'll go ahead and start through that. First, I'll need.
So just for the record, would you tell us why we have to do that? We have new commissioners up here.
Yes. So the Fresh Start Act was passed, and whenever an individual is denied licensure based upon a criminal conviction, we have to go through certain factors and justifications to support that. So the first thing that we'll do is we'll need a motion, and all of these vote, a motion and a vote that the specific criminal convictions of wire fraud, concealment of material fact, making and subscribing to false income tax returns directly relate to the real estate profession.
So before we do, is this a roll call vote in each one of these?
No.
Yes or no?
No.
Okay, and as Mr. Bagley abstained on the main motion that we just considered, can he vote on these, or do you recommend he stay out of these as well?
I would recommend that he would continue to abstain from the vote.
Okay, perfect. Are you going to suggest?
So we need first, we need to vote a motion to state that the three offenses of wire fraud, concealment of material fact, and making and subscribing to false income tax return directly relate to the real estate profession.
So moved.
Is there a second? Motion by Ms. Frank, seconded by Mr. Wood. It's Mr. Gwynn. Sorry. I've had a
Sounds
It came from that corner.
Yeah.
Okay, so if you agree that wire fraud, concealment of pertinent facts, and filing a false income tax return is relevant to the real estate industry, you'll vote yes on this motion. Is that correct, Ms. Matlock?
That's correct.
All right, if you don't think it's pertinent to the real estate industry, you'll vote no. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes on a 6-0-1 vote. Ms. Matlock.
And then next, we'll go through the Fresh Start analysis. Next, we have a set of 6 factors that we need to consider, and I'll read a factor, and if we can have a general discussion from the commission members about each factor and why it applies, and then once we're done with all of those, we'll have a vote about those factors. So the first is the nature and seriousness of the crime for which the individual was convicted.
Comments? Like someone on this commission saying significant, I mean serious. Those charges are significant and serious.
I would say that the reason is because she took money from others and that she was convicted of fraud.
Okay. The length of time since the commission of the crime.
The length of the time, it was 2011 when she was sentenced?
Yes. That's correct. So the length of time from when it's been, the crime was committed and now, whether that has an impact on whether they should be licensed or not.
What impacts the time is that she served 57 months in prison, and since then, she's not really been employed. And so that's why, as far as the time, we don't think that she's had time to.
Are you thinking maybe that the fact that you're saying it's been 5 years, maybe that she's been out in incarceration, is that right? But she really hadn't reestablished anything since that time frame. I mean, there may be other reasons why she hadn't been able to, but there's been no reestablish of trust or anything to do that.
Okay. The next would be the relationship between the nature of the crime and the purposes of regulating the real estate profession.
Our purpose is to protect the public. There were a number of people that were harmed by her offenses.
The next will be the relationship between the crime and the ability, capacity, and fitness required to perform the duties and discharge the responsibilities within the real estate profession.
I think that goes to how I mentioned it. There's too many parallels to what she was doing to what she can also do in the real estate business if she had a license.
And any evidence of rehabilitation or treatment undertaken by the individual that might mitigate against the relationship of crime to the real estate profession.
She gave us none.
Okay, and the last one is any applicable federal laws regarding an individual's participation in the real estate profession. There are none specifically. So we'll need a motion to adopt those factors and the reasoning.
Move to adopt those factors and reasoning.
Second.
Discussion on the motion. And again, with this procedure, it's dictated by state law at this point. It's not anything Ms. Matlock thought we ought to do. She has no choice but to put this in front of us. All right, if there are no questions, we'll vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously.
Okay, and I will now read the Fresh Start analysis justification statement. The Tennessee Real Estate Commission on March 11th, 2020, decided to deny licensure as a result of your conviction on or about July of 2011 for wire fraud, concealment of material fact, and making and subscribing to a false income tax return. The Real Estate Commission has decided to take this action after considering the following factors as set forth by the Fresh Start Act. If you wish to contest this determination, you may file a petition within 30 business days of the receipt of this notice in Davidson County Chancery Court, at which time the Commission must demonstrate by a preponderance of the evidence that the licensee's conviction is related to the applicable occupation. And I will now need a motion that that justification statement is adopted.
So moved.
Second.
Ms. Franks makes a motion, and Mr. Wood seconds that motion that the statement just read into the record by Ms. Matlock be adopted. Is there discussion? Those in favor of that motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. All right, thank you, Ms. Matlock. Ms. Googe, Mr. Powell, thanks for coming down. Sorry we couldn't accommodate you today. All right, Commissioner O'Kay, you want a break? If not, we'll move on to Jacob Edwards. Gentlemen, if you'll come forward, Ms. Matlock will swear you in. Just so I'm clear, who is Jacob Edwards? Okay, so you're the applicant, okay. Ms. Maxwell?
Okay, before you, you have applicant Jacob Edwards and his principal broker, Benjamin Eric Kistner. Mr. Edwards has taken the Tennessee Real Estate Affiliate Broker exam. and there's a correction, there has not been any disciplinary sanctions for the firm. An applicant's summary of criminal and disciplinary sanction is felony DUI. Mr. Edwards' statement and the letter of recommendation can be found on your iPad.
Ms. Matlock, before we get started, the DUI gets you here automatically? It was,
It's a felony. So as
felony deal.
our statute, our rules are now written, it's all felonies.
okay. And again, sometimes I pretend I know what I'm talking about, and sometimes I don't have a clue when I'm pretending. But with new commissioners, anything you can help to explain what's going on would be helpful. All right, Mr. Edwards, what did you think about that last one?
Very nervous, sir.
I'm just checking to see what you thought. Why don't you give us some background, why you're here, and what we need to know?
Sir,
Please, get as far as it'll go.
my name is Jacob Edwards. I'm 28. I'm really nervous. I'm really sorry. When I was in the military, getting ready to get out, I was just emotionally immature, reckless, and I was an idiot. I made the biggest mistake of my life, and ever since then, I've been trying to do more. I currently own my own business, a successful landscaping, hardscaping, and construction company. I was a diesel mechanic for about 5 years. I actually went to work release as my punishment instead of a prison. I went to work release, and I got a job with a company working as in the body shop. I was just sweeping up the floor and killing cockroaches out of dirty used semi-trucks. And 5 years later, I was living in Denver, Colorado as a truck salesman for one of the largest truck companies in the United States, Transwest Corporation. I've dealt with and handled quite a bit of money since my time in my felony. I've never been in trouble since or before, and I think that's about it, sir.
Commissioners?
I've got a question.
Yes, Ms. Franks.
So I've never heard of a felony DUI. What made it a felony?
I broke both of my ankles, and I actually hit another person, and they fractured their leg. And since the judge, it's a long story, but I feel like the more I talk, the worse I look. So I'll
Just
try
tell
to
me
be very
whatever you want
quickly.
us to know. I don't know the different, I didn't know there was a felony DUI. That's what
Yes,
I'm-
ma'am. If someone is injured, the judge can deem it that it's a felony if he feels that the injury is bad enough. So technically, I was given a felony for injuring myself for both of my broken ankles. And the judge, I was underage at the time, under 21, and I was going through a divorce. My brother had just had a brain aneurysm, and another brother was in the hospital. It's a long story, but I didn't know how to handle it emotionally. I had an officer decide to ask me if I wanted to go out. I was underage, and the entire purpose of him taking me out was to get me drunk. He had my keys, and I have no idea. He told me that he was messing with a girl at the party, and I ended up getting my keys from him back somehow, and that was when that happened. The judge wanted names. He wanted to know where I got the alcohol. At the time, I felt like the best decision would be to take responsibility singularly, not throw anybody else under the bus. So I wore it myself on my own shoulders, and I didn't give the judge any names. So he decided to hit me with the maximum that he could hit me with.
Did you had, what, 3 years of probation?
I'm sorry.
Go ahead.
I had 2 years, supposed to be in confinement. I was in jail for maybe a few months, and then I immediately went to work release, where I got the job at Nextran Corporation and continued to work there for almost 7 years. After that, and then I got early release because of good behavior.
And then I started probation, which I also only did half my time, so I did a year and a half of probation and was then released early off of probation as well for good behavior and completing all of my probationary statutes early.
So the felony was due to you hit a car and someone else was harmed?
Yes, ma'am.
Okay. And I noticed somewhere that you speak to young adults. Can you tell me about that?
Yes, ma'am. I didn't have a good life. I don't have a dad, and I just had a son. And I go and speak at high schools to sports teams about the dangers of emotional decisions and the wreckage that it can create in your life. So I try to.
I appreciate that.
Bobby?
This is probably more for Anna a question. So this has been like 9 years on this felony? If he'd waited a few more months, it'd be 10 and he wouldn't have to come before us. Is that right?
So we go by the date of conviction. So the
Okay.
date of conviction on here is 2012.
Okay.
So it wouldn't be until 2022.
Okay.
Other questions? Joe?
To stay consistent, Eric and I are friends as brokers, so I'm going to abstain from.
Okay.
You know everybody.
Yeah.
Well, today.
If you were friends over
And I'll add, I know Eric, but hello? I know Eric, but I don't feel like it is something I need to recuse myself from, but I did want to throw that out.
So
on the
Joe,
table.
are you recusing yourself?
Just to stay consistent.
Okay. Okay.
I feel like I can.
Steve's asked something.
Question.
Yes.
What happened to the other person that was in the car that you hit, or how did all that? You broke 2 ankles. What happened to the other?
Goody Williams is a great woman. She actually she decided that she did not want to pursue any criminal charges. And the only reason that I was convicted was because the prosecution actually picked it up and decided to charge me themselves. But they actually had no victim. She was amazing.
Did she break anything? Or?
She fractured her leg, but after 4 to 5 months, the cast came off and she was healed 100%, no lasting damages, sir.
What time was the accident?
It was 2 a.m. The day after, the day after Memorial Day. It was Memorial night that we went out, and it was that morning when I crashed.
Were you in the military at the time when this event took place?
I was actually getting ready to get out.
How long were you in the military?
Just short of 4 years, ma'am.
Thank you for your service.
So, Mr. Edwards, I'd like to talk about the future, not the past at this point. Why real estate, and how do you see yourself 3 or 4 years from now if you do have a license?
Real estate is something that I've always been interested in, but also my current company, my business, I'm really trying to break into the property management side of the industry. I really want to get residential buildings and apartments and condos and do the maintenance, the yard work, and also deal with the tenancies and stuff like that. And then also I want
You'll get over that wanting to deal with the tenants real quick, okay? I can tell you that. The grass don't talk back to you, but the tenants will. So.
When I moved to Colorado, I got my first taste of the real estate market. I just sold my house in Florida, and I rented that out myself for the duration of my 3 years in Colorado, and I really enjoyed it. And I thought to myself, it's easy money, and then I started learning more about it and the complexities about the contracts, and then just dealing with Mr. Eric here, giving me all the information that he has been amazing. It's just something that really interests me, something that keeps me going. I'm the kind of person that needs to be moving and needs different things. I like to talk to people, like to meet people, and this just, it really felt like it was a really good fit, and I could continue to grow my own personal company as well alongside the real estate firm.
So, Mr. Eric, is he the same as Benjamin or Ben or?
All the above.
What do you go by?
I go by Eric.
Eric, okay. All right, any other questions at the moment for Jacob? If not, Eric, if you will tell us why you're interested in having Jacob affiliate with your firm.
Yes, well, I met Jacob in November of last year. He came and shared his business plan with me and his desire to get into the real estate side. To give you a little idea about his business, he is a person that you would call when you need anything done in your house, whether that's a fan or a room painted or carpet or hardwood floors. Those people are very hard to find in today's world. So he sort of provides all that service, mows the yard, shrubbery, and he suggests at that point that he would like to get in more into the property management side of it. And as you said, I told him that was nuts. But with his personality, I felt like he did have an opportunity to build a real estate part of his business. So his vision is that somebody would call him for all of their real estate needs, no matter what that is, to sell a house, buy a house, lease a house, whatever it is. Factor that in with his work ethic. I've used him several times as using his services. I've referred him out several times. He does great work. He also has an outstanding personality. But then you factor in his military background, the yes ma'ams and yes sirs that you're hearing up here today, that's not for you all. That's how he talks. He was a standout every time I've had him around anybody. They've always wrote back and said, hey, thank you for sending Jake my way. He was a quality guy. And as a person who refers a lot of people during the course of business every day, you don't see that. So I know that he's special. We know that we had this issue when he was 20. You remember he left high school early to go into the military and spent 4 years there and comes back, and as he's transitioning out, his wife has left him. You know, I see why his buddy wanted to take him out and get him drunk. He was in a low place, made a mistake, but we don't measure, and at least I don't measure Jake by what happened that night. We measure him by what he's done since then, and he's went on to be a hardworking individual, grow his own business, excelled in school, and then now he's here in front of you guys today. So
I've been calling you Jacob all along, and it's Jake, and this is Eric. I mean, it's almost like you guys have aliases.
I wanted to make it as confusing as possible for all of you, so we could just kind of push this through, right?
Yeah, Ms. Torbett?
Yeah, I make a motion that we approve.
Second?
Second.
Thank you, sir. Motion by Ms. Torbett, seconded by Mr. Gwynn, that Jake Edwards' application be allowed to proceed to get a real estate license. Is there further discussion? If not, let's vote. If you're in favor of that motion, vote aye.
Aye.
If you're opposed, vote no. That motion passes on a 6 aye, 0, 1 abstention. Mr. Bagley. So, Jake, can you come back in a year and tell us how good you're doing?
Yes, sir.
Well, you could just tell either Joe or Stacy, and they'll come tell us. But
we'll get word to them.
We would love for you to be successful.
And also, I think it's important this morning, where the last case was very difficult for all of us, because we like to be able to see that people have progressed in their lives and they're moving on and they've changed. So I feel like we had two examples of what happens when you don't, and with you, what happens when you do. And so we're proud of you, and we wish you all the success. Eric, thank you for leading him and train him well.
You got it.
All right, guys, we're going to take a 10-minute break. Thanks for coming down. Be safe.
Thank you. Guys.
Thank you all.
Perfectly appropriate to go talk to those guys.
There'll be a lot of real estate agents out there ticked off to lose their handyman.
Yeah.
They're going to be ticked off.
Does he work in Franklin? I need somebody like him.
Whatever it would be.
It's real hard.
You wear that coat often?
Yes, sir.
Realtors love those kind of guys.
Yes. My wife and my mother would be absolutely just mad if I didn't wear a jacket.
Good luck to you.
Thank you so much. Good. Really appreciate it. Thank you, guys.
Sometimes it's pretty painful up here.
The first one was tough. Makes no sense.
First day I
But
was
you
here.
see the difference in remorse and
Oh,
taking
yeah,
responsibility
absolutely.
in these two.
First day I was here, had a guy that come, and he had been in jail killing a guy, and but it was.
Want to get his real estate license?
Oh yeah, oh yeah.
Yeah.
But I mean, he was part of a group. They were all like in San Diego. They went to Tijuana. They all come back drunk, And so there's a group of them, and they're in a parking lot mouthing at another group. They ended up getting into a fight, and a guy in another group ended up getting killed. And so he was one of them, got to go to jail, and
Yeah,
spent
right?
many
Okay, so it
years
wasn't just me. I
in
wasn't
jail.
trying to-
I mean, when I first read it beforehand, I was like, he's a murderer. We don't need him in my house. Okay, and then I got here that day, and everybody else was kind of, and he had become like a youth minister. He got out of done a lot of good things. Sound like this young man. Ahead, and everybody else was like, "Hey, he's good." And I mean, I came away. I was sick. I called John the next day. I said, "I didn't sleep all night. I've been
Really?
thinking murderer going in these houses."
My very first meeting, there was a man who had killed his child. I was the only. So at lunchtime, here, and I said it publicly. Why would we give? I mean, what is our standard? Is this our? But I've also.
You know,
So, how many people get their license who are felons?
Well,
I mean,
we changed the rule.
Would
Most
Anna
people
know?
don't even want to come in here if they've had,
Right.
But we have one a month. We have at least one or
One
two
every
a month.
But we've changed the rule about 3 or 4 years ago. It's the 10-year rule. If it happened over 10 years
I can
ago,
barely stand on two
come in
legs.
here.
I put one out, it could be dangerous.
Right.
I am going straight to the ground.
I would think
Yeah, my leg.
that
That's
first lady.
How are your ankles?
She had.
They
I don't
are,
know when she's been out of prison. I didn't calculate it.
They're bad.
2 years.
I've got a veteran's disability. You know, for my ankles, I have like 5%.
Or for.
Worked here every day.
For long periods of time.
I paid my taxes.
Yeah, I had to check on.
I
Actually,
got
more
clean,
Airbnb.
financially.
I'm gonna be walking and stuff
This wasn't
with
the
my
first
son's wife. We get
ask, if you will.
The
It would have made a
the
little.
scariest part of it was
on it.
I don't know if I believe that. I mean,
how could she not? No, well, I mean, our standard needed to be.
I was gonna. I mean, if we'd had something second,
That restaurant's gone.
how did you feel dealing with a criminal, basically? I mean, we can get into a long discussion about illegal immigration, and I'm sure everybody's got a different opinion on it, but
On the second floor in the
of the
building.
day,
I need to go anywhere.
a person is here in the United States.
No, sir, I did not.
Excuse me.
How long? I mean,
Yes, sir.
how tough is that?
I was telling my husband about this case last night, and he was like, "Oh yeah."
Bodyguards in Israel.
I was like, "Yeah, I guess I am."
Thank you.
Careful.
See ya.
that what to do. I can always have the court represent it and bring it back to the commission next month. But I would prefer to just. Yes, I'm sure.
Yes.
Okay. These days, but.
Jazz hands.
Yeah.
Oh, okay.
Yeah.
Ross White, Director of Education.
Okay.
If I can help you in any way, shape,
Sure,
or form,
Ross.
let me know.
Thank you.
And, I enjoy what we do here. I think you're gonna really enjoy it.
Okay, thank you.
And great group of folks to work with.
Yes.
I've been in here going on 6 years now.
Okay.
I've been with the state for 30. So,
Wow.
I'm an attorney, but also the director now of the education.
Okay.
It's a really
Are you the one that
all
approves
licensees.
courses and stuff like that?
I review them.
So I didn't know that it was a
You
process.
approve them as a commission.
And how?
We do, we
Today,
approve?
Even if
yeah,
you did
every,
that, I
every
think
month
that-
I'll bring
so
about 30 new,
on
courses in
So
that have been
Tim's
reviewed, all the
Okay.
instructors, all the new providers and so forth, and then present them. And
So
then
when
you
Mar,
guys-
when Mar has a new thing they want to do for educational credit, they send that to you?
O'Hara sends them to me.
And then it comes here?
That's right.
Okay.
That's it. And then, you know.
And that
about-
turnaround time is 60 days? or-
About 45.
40, okay.
Yeah, I get them, and it takes a while, but we have a 15th of the month cutoff.
Okay.
So if I get them after the 15th, it's going to be the following month.
Right.
And if it's before the 15th, then it's usually the subsequent month.
Got it.
Yeah. But anyway, it's,
Okay. That
it's
should
a
be a
good
life
thing,
skill.
and we
Yeah.
have a lot of folks, and
Yes.
very rewarding.
Oh, that's good.
What we do, and man, I'm glad you're here.
Oh, thank you very much.
And my wife is from Memphis.
Oh, really? Good,
Yeah.
good for her.
Yeah, I had the good sense to marry a woman from Memphis. She worked here, and we met.
Okay.
And so we got 2 kids. One's
You don't have
PT and
to,
one.
no.
My daughter teaches.
They didn't
at
even give me a
Chimney.
lanyard
She's
for mine. I
on
just
there.
have the thing and stick it in my purse.
Fifth year.
Picture with her phone.
Right
here.
Oh,
No,
oh.
Kevin was like,
And,
Rover.
okay.
Yeah. So I got a prayer in Memphis. Just letting you know, my in-laws are there.
Okay. Let me give you a card here.
Yeah.
Real quick.
Thanks, Steve.
Hey, in the
Have
past.
any questions of us? Let me know.
Very good.
Hey, buddy. How are you?
Sorry about that.
Oh. Did you go see Bill? See, we're not used to having anybody wearing uniforms.
Government people look at it.
Oh, really?
Government people look at it. You know, and with Trump, they had to,
I kinda like the
commerce and
corner.
insurance people were with
see
them.
everybody.
Because
Yeah.
they did all that in Putnam County too, so.
well, it was easier to get it.
I didn't think that was.
Just here.
But well,
Uh-huh. Oh, yeah. My daddy is. I have to keep my, I have it in my phone. Certain times I can't.
Oh, thank you very much.
How many kids? Oh, not 8. Oh, I know, and you know what?
All right, ladies and gentlemen, let's get back to order.
The other one helps with daddy. She gets so mad.
Like so far removed from.
I don't know why Joe's hanging out over there.
That I can move?
He's using the 3-foot rope.
Yeah, you're afraid I'm gonna give you coronavirus, aren't you?
I thought a while ago I better get my cough drops out. I mean, cough.
All right, ladies and gentlemen,
Well, you are
Please take your
volunteering for
seats.
Tennessee, aren't you?
Okay, that attorney's still here for that lady.
please take your seats.
You need some water?
All right.
Is this guy here?
Yeah, and he's going to take some time.
That's what this is.
Yeah. Yeah. All right, we're back in session. Aaron, are you okay? All right, up next is an informal appearance by Mr. Anthony Willoughby. Mr. Willoughby's here. Ms. Maxwell, Ms. Matlock, whoever would like, give us some background on this before we get started.
Okay, I can give you a little bit of a background. In front of you, we have printed a copy of an agreed order that was signed and approved by the commission as well as by Mr. Willoughby. It dates back to May of 2018. essentially, there were a handful of complaints presented to the commission, and I guess I'll let legal correct me if I misstate this, but based on those complaints, the commission agreed for Mr. Willoughby to voluntarily surrender his license. And so at this point, in order to obtain a license, he has to come before the commission.
Mr. Matlock, anything to add?
No, nothing else to add. If you want, the more specifics are outlined in the stipulated facts. And there were, I apologize, 5 complaints, and most of them were in regards to violations of 62-13-312B5, which states failing within a reasonable time to account for or to remit any monies coming into licensee's possession that belong to others. So this was entered in on May 7th, 2018.
All right, so several, let's see if I can state it back to you. Several complaints were filed against Mr. Willoughby.
Yes.
And at some point, do we have a formal hearing, or is
At
it?
some point, notice of hearing and charges were filed. So that means a complaint was sent to the Administrative Procedures Division to proceed with a formal hearing. But prior to that, there was an agreement with the parties that Mr. Willoughby would voluntarily surrender his license. And so we entered into an agreed order and a notice of voluntary dismissal for that purpose.
Okay, and so I'm not putting words in Mr. Willoughby's mouth, but I assume he's here to try to get his license back.
Yes, that's correct.
All right, and what if a license has been suspended, will he have to start over to get a new license if we agree to let him do that, or how does that work?
So the specifics, his license was voluntarily surrendered, which is the same as essentially revocation, which means that license no longer exists. So it would be up to the commission's decision how that license is reinstated.
Would it be reinstated, or a new issue?
It would be, the individual would need to retest and reapply as any other individual whose license has expired or anything like that.
So other options would be to take no action, which would continue Mr. Willoughby's current status of not
That's
being
correct.
licensed in the state. Okay. All right, Mr. Willoughby's here to speak on his own behalf and make the request. Mr. Willoughby, if you'd like to come up to this microphone here at the podium, that might be the best place for you to talk.
May I ask, we didn't receive this until this morning, which is a huge handicap, and especially to those who weren't present at the previous commission meetings when all this took place. Why are we, did this just happen in the last 24 hours, or?
No, that is sort of my fault. I was thinking as I was preparing for the meeting, things that would be helpful for you to have, and went ahead and printed that out.
So if you'd like, we'll take 5 or 10 minutes to read through it. I think it might be helpful. It's a good point. Mr. Willoughby, give us 5 minutes. We'll call you back up here. Let commission read through this.
Yes, and if you look under stipulated facts, those are the facts that we found him guilty of and based the conclusions on.
That's not quite correct. It's that he agreed we're correct.
That he agreed we're correct. That's right.
Okay, so take a few minutes, read through this, and we'll get back in just a second to Mr. Willoughby. All right, so the request here today has to do with reinstatement of a license. It is not, in the chair's opinion, to rehear this case. So the chair will make every effort to try to keep the discussion focused on whether or not Mr. Willoughby should be allowed to get a real estate license in some form or fashion. And I'll ask Mr. Willoughby to try to talk to that topic as well. We're not here to hear the case. That's been settled. So, Mr. Willoughby, I'm going to declare that you get to make an opening statement, and I hope you'll keep it at 5 minutes or less, and let's see where it goes from there. You have the floor.
Well, yes, sir. And first, I want to thank the board for allowing me to come and revisit this issue of my broker's license. And just following up on what Mr. Bobby mentioned earlier regarding the incidents in Mount Juliet, my daughter and her family lives in Mount Juliet, and I thank God there's not any more damage. Amy Willoughby, attorney Amy Willoughby, runs the Office of Conservatorship here in Nashville, my daughter, and I thank God they're not injured, and they were out of lights for over a week and still stayed in the property. Now, I'm here to answer any questions you may have regarding this issue of my license reinstatement, and definitely to make a formal request to reinstate the license. If I want to offer full respect for legal counsel, executive director, any words they may have had as far as the stipulated facts. There were a couple of items mentioned, but there was a couple not mentioned, which is very pertinent in the event that anyone here are not familiar with them. The first item I want to mention that were not mentioned is the fact that once I was informed of the situation at the leasing division of my company, we ran a press release, open apology. We were always been openly apologetic. Press release asking if anyone was injured at my company, come forward and let me know. We'll make it right, because I was unaware. Now, my leasing division was run by a family member and another licensed broker, and that doesn't take me off the hook. I assume full responsibility of anything that takes place at any of my companies. I've been in the real estate industry as a broker for 30 years. You check my record, clean record. I've been grandfathered in education. I've always stipulated education and trained my agents. Never had infraction. That was the only thing that came up, and everything in the stipulated facts, if I'm not mistaken, legal counsel and executive director, I have full respect. All the complaints were dismissed, and it states in the stipulated facts that no mishandling of monies were found by Mr. Willoughby or his company, and all the complaints were dismissed in the stipulated fact. I must bring that out. Yes, I did voluntarily allow my license to be surrendered. It was a category it was put into. But at the time, I didn't want to fight with this because I was just declared stage 4 cancer a few months prior. And that leasing office, I closed in August of 17 as a result of my treatments at the West Cancer Center. I maintained my brokerage, moved to a smaller office in a law firm. The leasing division decided they wanted to continue. They reincorporated and opened an office in another part of town. These incidents on the table came to my attention months after I closed the division and released everyone from my office. I didn't ignore it because it had my name on it, Willoughby, but the new company was Willoughby Leasing. I want to clarify all of that. It wasn't an Anthony Willoughby thing. It was Anthony Willoughby's company, and I assume full responsibility, and I'm apologetic to anyone that had any losses at my company, and I put that out there. Now, to say all of that, also in the stipulated facts, it may mention that I have full respect to legal counsel and executive director. When it relates to my voluntary surrendering of the license, the court order signed by all parties indicated that I would have the right to come back and request to apply for reinstatement, not to reapply for examination. And I have full respect for this board and whatever you might want to say or deem for me to do, but that's the agreed order, and it should be on the last page of the order for those of you that were not familiar with the situation. again, I'm not trying to weasel out of anything. I have a 30-year record. I went into real estate business at the age of 23, became a training manager at 26, became a general manager of over 100 agents at 28, over my company at 29, and I've had a long-running career, 30 years of brokerage, no issues. I mean, little things here and there, but nothing to speak of. And I'm not the type of individual that run rapidly hurting people in any way whatsoever. These issues that came about were not from my hands, but from my company. I did take every effort to clean it up and do whatever any broker would do in a situation like that. And I would do it again, but I would never get into the leasing business. Now, leasing business is different than brokerage. In the brokerage business, we handle the earnest money, and you'll find through my records, I had several audits through the commission, never had a problem, 30 years. In that leasing business, that department only took applications, took the information, took the deposit, and sent it to the property manager. And the property manager held the money. And many of these same people that complained lost their money because they didn't sign on time. I even dealt with that. I went and talked to the property manager, said, look, we need to get these people's money back. So it was a little different. We weren't in the situation of holding deposits for rental properties because we didn't do that. Only the property managers held those. But we were responsible for collecting the money and sending the package to the property manager, which if they leased to that individual, they would pay my company a fee, a commission. One half of the first month's rent, depending on the amount of business they sent. If there was a company sending us very little business, the entire first month's rent. But that's how the income came in, and then the agents made one half of that. So basically, it was a situation a little differently than maybe put on the table, and I want to just clarify that, not saying I am innocent of anything. Anything a brokerage company does, he is responsible for, and I took full responsibility and apologetic to everyone. And not only openly, but in an open press release, we did have that done to say if anybody, I'm not aware of, had a problem, come forth, and we'll make it right. And I don't know what else I could have done. But
that's a good start, Mr. Willoughby. Yeah. That's about 5 minutes. Let me ask counsel, Mr. Willoughby referenced a statement in the agreed order about the right to have the right to get his license reinstated. Is
that's
where
the way
is
it reads,
that?
sir, yes.
If you will look on the second to last page, it is in paragraph 29.
Right at the end of 20.
Okay, got it. Questions for Mr. Willoughby?
I think the question is really, because I think Mr. Willoughby is basically saying he just wants them reinstated, but did I hear from what Anna said was we can't just say, here's your license, that he may have to take the test again?
I would leave that up to your interpretation. It says in the order, without prejudice to his right to apply for reinstatement in the future. As it is presently, we don't really have like reinstatement. Like that's not, the term of it itself is not addressed specifically in the rules or statutes. So I feel like it could be left open to interpretation. So he has definitely the right to apply for reinstatement, but it doesn't clarify what that means.
Okay, here I just want to muddy the water more. Okay, so if we were to say, here's your license back, is he grandfathered again?
I think that would still apply.
But if we were to say, you got to take the test and pass it to get your license back, does that mean he has a different date for his license and he's no longer grandfathered? I told you I was going to muddy the water.
So according to Ms. Maxwell just informed me, the expiration date for his license is 1/10/2019. So that would be over a year anyway of his license being expired. I think that if a new license date is issued, it would mean that you would lose your grandfathering status, but I don't know, just like the way that our system is set up, that all of that information previously would revert back, if that makes sense.
I suspect this commission can do whatever we want to. So if we say reinstate it and activate it today, as if it never expired, we could do that.
I don't see an issue with
Okay.
that.
That's just for the record. Bob, anything else?
I remember us hearing from you in Memphis, and I have to admire you. I mean, there was a lot of people in the region. All this thing got on top of our agenda really fast. There was a lot of people screaming about money that they hadn't got their money back. I appreciate you getting to the bottom of it, and so many times we ended up getting in the middle of something, and the people never get their money back. But in this case, it did happen, and that makes your case very unusual for things that we've done. But I recall from Memphis, and I believe you had counsel there, and I came away from that not feeling that you really took any responsibility for it. And that was my biggest frustration of that day, was that neither you nor counsel thought it was your problem. I hear different today, okay? And so I'll just kind of go ahead and say this. I mean, I don't know how we're going to do about this. I feel better. I mean, I remember it was a previous commissioner up here that they said that they were from your area and they knew you had been a real estate agent for a while. And their recollection, they never heard anything bad about you. And then all of a sudden, we got all these complaints at one time, and I think kind of now we kind of know the backstory of where it all came from. So based upon all that, I'm ready to see about getting your license back. I think we're at that point, or at least I'm at that point. Okay, now how it goes about doing that, and if everybody else feels that way, but I just kind of put that out there is where I'm at right now.
Okay, Steve.
Question for Mr. Willoughby. I wasn't here when your case was tried or whatever a couple of years ago. What's happened to Willoughby, your company? Who is the principal broker? Is it still operating, or how's it working?
No, sir. I actually, when the commission asked me to surrender my license, I wouldn't personally ask out through my counsel. There, I saw that actually and agreed to order and said, okay, fine, I can't deal with this anyway. I got treatments to go to. But at that same time, my real estate company was also dismissed. So we've done no business. Now my corporation, I kept open. The Willoughby Realty Corporation, state of Tennessee, is active, but there's been no activity.
So you've really had no business in the last, since your license was suspended?
In 18, that's correct.
Okay.
Yes.
The questions?
My question
Ms.
is just
Corbett?
for Ms. Matlock. So, just procedurally, if his license expired over a year ago, if we were to reinstate his license, what would the expiration date be? Would it be start today?
It just depends on what the commission, your decision is. So if it is reinstated today, it would be 2 years from today.
And again, in my opinion, we can do whatever we want to with this license. We can reinstitute it because a previous commission signed an agreed order that said it could be reinstated. And so I think we're bound by that, or we at least have the latitude of considering that at this time. Ms. Franks.
I would like for especially those of you who weren't here when Mr. Willoughby appeared before, the problem was that his company was taking money for rentals, and the rentals didn't exist. Okay?
What do you mean the rentals didn't exist?
He rented units that didn't exist.
You mean physically?
Physically did not exist. And so then the people wanted their money back. He had nowhere for them to move after they took deposits. And so then there was nowhere for them to move. And so then they asked for their money back. And it was, I can't remember how long, but they had to come before us complaining that they had not gotten their money back. So, months.
Mr. Willoughby.
If I may elaborate, that is maybe an illusion. I don't know where that came from.
I got it right off the internet.
That's fine, that's, maybe someone said that, but we were leasing agencies. We never handled the rental properties, we never handled leasing, we never handled approvals. We only took the data, we processed the way a loan officer would, the application, the verification of rents, and sent that package to the property manager. And if the property manager leased or not leased, that was out of our company's hands.
So who owned that other property management company?
There were 10 or 15 of them. We were just leasing. As a leasing agent, you're not property managers. You don't lease properties to anybody. You collect the data and send it to the property manager. Now, I'm thinking that some of the people that may have complained misconstrued our office as the property manager. But there were several property managers around the Memphis area. We never managed any property. We only collected the file, gave it to the property manager.
You didn't collect any money?
We collected the file with the deposit, and all of that went to the property manager.
You collected the money?
And all of that went to the property manager's office. And several of these people that you're mentioning of, the property manager, when they did not go over there and sign on time, took the earnest money and leased it to someone else. We did not do that. And that's been the biggest misunderstanding. My office only took applications, prepared the package, sent it to the property management company. And some of the people even complained that we thought you guys were. I said, no, we were never, ever property managers. We just handled the leasing. Leasing and property managing is two separate entities. When they collected the data, the deposits, send the package to the manager. If they leased to that individual, they send us a check. But once we send that package, we're done.
Who did they write the checks to?
They would write the checks to my company.
Okay, so they wrote the checks to your company, you took the money, and then when people wanted their money back, you did not give them their money back. Is that correct?
No, ma'am.
What's wrong about that statement?
That is not correct, ma'am. The monies were then written from my office to the property management company. I think in my very first meeting in 18, I actually brought the file, the property management company information, the checks, showing the checks going back out to the property manager with the file.
You took it in as income and then wrote a check out to another company?
No, not as income, no, ma'am, as deposits.
Well, it was income to your income tax if you took the money and put it in your company's name.
Well, an escrow account, it wasn't income, it was non-interest bearing and went straight from there to the property manager. And I did bring that thick information in my very first hearing 2 years ago showing how that went. The monies came in. Once the package was finished, a check from my company with the package went to the property management company.
So
we were done.
We're not going to go over all your information. I remember last time it took hours with all of your information.
I had to have that clarified.
I do remember that it was a unanimous vote on it, and we did take the time, and he had an attorney, and we listened to all of the facts about it. The only thing really that we're here for today is for you to show us that why should we renew or let you have a license? What have you done to make that something that we should do for you?
Well, again, in the stipulated facts, ma'am, it does state that I never mishandled any funds that did come out.
No, what have you done? We're not, I'm talking about,
that
since you got this,
I understand, ma'am.
what have you done the last year?
But I have to clarify that I never misappropriated any funds. I'm being accused right now of doing that. I never have.
We hear you.
Okay, and that's been cleared, and that is in the stipulated facts. Now, since that time, I have not been working as a real estate broker because I have not been able to. I have, when I closed the leasing division and dismissed those people in August of 17, I moved my office to a single-man office with conference rooms in a law firm. And because I knew the attorney that owned the building, he said, hey, come on over here and work from my office. And at the time, I still work in brokerage because this incident came about, I think, in February, March of 18, but in 17, when I moved, it was a single-man office. So again, when I was made aware of these problems, I acted as any broker will, appalled. Let's get to the bottom of it. I went to the property managers. I got money back for people. They got their money back. So I never misappropriate any funds. Now, since that time, this same office that I leased in the law firm, They handle pension for veterans, aid and attendance, and that sort of thing. And I was asked by the attorney, which knows me and knows my history as previous president of the Real Estate Association twice, and I've been a regional director.
What real estate association was
the
that?
National Association of Real Estate Brokers, the Memphis chapter. And I have a press release as a young, actually at the age of 34. I've got a press release.
Mr. Welby, what I recall most about last time we met with you is you had an extensive resume, and we'll stipulate that. You don't need to go through that again.
Well, she asked me, sir.
I got it, but
No, I said, since this, what have you done?
Well, that's a part of what I'm saying now. So this attorney is aware of my work and how I handle people, and asked me if I could come and train with this office, this attorney, to handle veterans and their pensions and that sort of thing. Aid and attendance, I met with them and I trained with them for several months, and since that time I've gone out, I've handled, and I currently do, handle people in groups, seminars, explaining, helping them to understand how, and we've just tons of veterans are receiving the monies now that didn't know about the aid and attendance program. So I go out and meet with property managers of high-rise buildings that have many elderly veterans in there, and I meet with them and arrange for seminars. I bring some of the team from the law firm. I am a speaker, and I'm not boasting. I just am a speaker, and I do that. And I speak, and we handle them, and we do that sort of thing. So I actually work with the public, and I do that now. And we obtain their aid and attendance pension plan, which is what it's called, and I do that right now. Now, other than that, I mean, I was just released in December from my treatments, so I've been ordered not to be in any stressful positions, and I thank God that I have not been in real estate because it was too stressful to be in everyday treatment and run a brokerage firm. But I would have tried if I had the opportunity. So I have not done real estate, but I have been engaged with the public. I have worked, but it's more of a leisure type of thing, not an everyday grind, and enabled me to stay out there and dealing with people and dealing with the public. And I still do that. The name of that firm is called Bradley Law Firm in Germantown.
All right, so I'm going to just throw this out there, Commissioners. So the question in front of us, as I see it, is 2 years without a license long enough for Mr. Willoughby? And if you don't think it is, then your vote will be easy. The question is, what is the motion going to be to vote on? And so I would encourage any member of commission who feels inclined to make a motion at this point so we know what to talk about.
Can I ask another question?
Yes, sir.
Mr. Willoughby, do you think that your leasing department is what really got you in trouble, if you want to call it that? Meaning you had a company that you were running for 30 years, and then you started another division. Am I getting this correct? You started another division called Willoughby Leasing.
Correct.
And that's when things went haywire? Is that, or had Willoughby Leasing been running for 30 years and then it all of a sudden started keeping deposits?
No, well, we've never done that. It's just the people that paid them at my office, and they assumed that, but they later found out their money was at the management company. We didn't have it. But Willoughby Leasing ran for a couple of years prior. To answer your question, Willoughby Leasing was added on. Had a family member come of age and want to work in the business and train for several years. And I had another person that had been with my office 20 years, and she wanted to run it, so I let them do that as a division. And it was very harmless because at the time the market was very slow and enabled these particular agents to receive $300 or $400 a week and pay by just doing that. So I allowed it. I didn't want it. I said, look, this thing does not make any money. I mean, when you get through, I'm going to make $300 when you get done with a deal, and I don't need that. But I buckled down and let them do it. And so it went on for a couple of years prior to this under my supervision. But around that summer of 17, I was out handling my personal medical business, and that's when I started hearing about some things. So I shut it down. And then months later, I heard about all these things. So, and I read press releases and apologized, say, hey, if anybody got hurt in my company. But during my 30 years of brokerage, never a problem, ever. In fact, I had several audits come to my office, went through my books, because that was a routine thing back at that time, and never found a problem. Our escrow accounts are always clean. We had a full-time CPA on board, and never, ever had a problem with money. Never, ever had a problem. And we did not hold the money for this leasing thing. We just handled the paperwork.
Mr. Willoughby?
But it was brought to our office, yeah.
That's it. We're looking for nouns and verbs answers, okay?
I know, sir, but I just I didn't know how to answer it.
Ms. Torbett?
I make a motion that we reinstate his license, and that.
Okay,
My
so
motion is we reinstate his license.
is there a second to that motion?
Is licensed to what? Principal broker?
Yeah.
Yes.
That's as it was.
As it was, yeah.
Okay, that's the motion on the floor. Is there a second to that motion? Last call, second to the motion. All right, the chair's going to second the motion in a rare second. So it's properly on the floor, and the motion is to make Mr. Willoughby whole as he was prior to signing this consent agreement. Discussion on the motion. All right, since you're ready to vote, if you're in favor of reinstating his license as it was prior to signing this consent agreement, please vote aye.
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 That motion, there are 3 ayes. Those
Who are the 3 ayes?
those opposed, vote no.
Did you vote aye, Joe?
You want those now?
No, well, give me, so let's start
Okay.
over, we'll start over again. I got too far into this. Those in favor of the motion vote aye.
Aye.
3 votes, Mr. Begley, Ms. Torbett, to the chair. Those opposed to the motion vote no.
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 So I sense there are 4 no votes, that motion fails. All right, now, floor is open to a second motion.
I'd like to make a motion that we allow Mr. Willoughby to take the classes, the education necessary, and allow him to be able to sit for an affiliate broker's license.
Is there a second to that motion?
Are you sure you want to do the education again?
Yes. It sounds like he needed it to begin with. That was the problem. Because he's been grandfathered and he took no education. That was part of the problem.
Well, if you check my record,
So,
much education. I even have additional education.
You need to hold your
we got a motion on the floor, looking for a second. I would accept a second to the motion if that second asked to bifurcate the question so you could vote on both parts of it separately. I mean, would that do what you're thinking about?
I'm thinking, so you.
I'm going to rule the motion fails for lack of a second.
Okay.
Mr. Wood, what do you think?
Okay, Marcia and I are going to have a conversation here. Okay, so, but is your education, was it pre-licensing, or is your education after he gets his license, that he gets in the same rotation as everybody else with the 16 hours?
I'd like for him to get in, I would like for him to start over.
Okay, this is me. I don't think the pre-licensing helps him.
And why not? Because he's not had education for all these years.
Well, I think the pre-licensing helps you pass the test, okay? I would like it if he gets his license, but then he's got to get his 16 hours every 2 years.
What if he couldn't pass the test?
He will. He will. If he keeps coming back to us this much, he wants it bad enough, he's going to pass the test. But if he can, and if he doesn't pass the test, then he might want to go back to class or take a refresher course.
So you're saying let him test?
Yes, and if he tests, then he gets his affiliate license.
Okay, I'd be okay with that.
Okay.
Let him test, and
Okay.
then the
So the motion-
16 hours afterwards, he doesn't have to take the pre-licensing, but he has to test.
Yes.
Okay.
Let's somebody put that in form of a motion.
Okay,
I'll come to you, Steve.
so the motion will be that we allow him to sit for the test.
Which test?
Affiliate broker.
Yes, the PSI test. If he passed that, he'll have to pass the national and the state part. If he passed both of those, then he gets his affiliate license. And then his license date will start from that point, and then he'll have to get his well, I don't care how you do the date. I just want to say he's got to now start getting education every 2 years, like the rest of the licensees do.
And so he loses his grandfathering.
Right. The grandfathering is not there.
So the motion is to allow Mr. Willoughby to take the affiliate broker's test with no predetermined educational requirements.
No pre-licensing.
And at that point, if he passes, he fits in as if a new licensee.
Yes.
Going forward, 16 hours every 2 years. Okay. Mr. Gwynn.
Is the 16 hours, does one of the courses have to be the ethics course?
Yes.
No.
Oh.
No, but our state, we don't have to make him, but he'll be a member probably of the Greater Memphis Association, which is a national
They
member.
require it.
They require it.
Correct.
So it's
a
taken
National
care of through
Association of
them.
Realtors requirement,
All right,
not-
that's cool.
not a state requirement.
Track core.
Now we
The track core course is the requirement within the 16 hours. The
But not
Tennessee,
the ethics.
not a state requirement.
But you explained that. You, got it, all right.
Okay, so the motion properly made and seconded, if passed, will give Mr. Willoughby the opportunity to take the affiliate broker's test as quickly as he wants to. And assuming he passes that, then he'll fit into the regular routine and schedule of any other newly licensed agent in Tennessee. That's the motion.
Who seconded
Bobby made the motion, Marcia seconded.
it? Okay.
And I just want to remind you that we originally wanted to revoke his license. He agreed to voluntarily turn his license in. So that's the seriousness of it. After hearing for a full hearing with everybody of what the facts were. All right, I'm ready to vote.
As long as you're ready to vote.
I'm ready.
All right, if you're in favor of the motion, please vote aye.
Aye.
If you're opposed, vote no. That motion passes unanimously. You've got an opening, Mr. Willoughby, not the one you're looking for, but you can get back in business.
Now, I have the state core class I just recently took, and I have it passed here for the board. And
You have to have a license first before your education counts.
I understand, but I'm just, is it too late for me to ask the board to reconsider me to test as a broker?
As a courtesy to you, because of your
Is it-
persistence, I'll ask if there's a motion to reconsider. That's all I can do. Is there a motion by any
That's
commissioner
all
to
I'm
reconsider
asking.
the
If I
previous
got a
action?
test, I've had a 30-year record of perfect brokerage.
All right, Mr. Willoughby, there is no motion to reconsider. We appreciate your effort and wish you well, but we've made our decision. Thanks for coming down. Next, yeah, please. All right, Ms. Grisham, Rice Insurance. You identify yourself for the record.
Yes, good morning. I'm Cindy Rice Grissom with Rice Insurance Services Company. Our company is the administrator of the Tennessee Real Estate Commission's Group Errors and Omissions Program. We call it the E&O program. My family has been involved in real estate E&O insurance since 1989. And we started writing the group program for Tennessee in 1991 when Tennessee started its mandatory insurance program. We currently provide the programs in 12 of the 14 states that have mandatory insurance requirements for real estate licensees that have group programs. At the end of February 2020, we had 29,252 licensees that were enrolled in the Tennessee program. And we've been pleased with the number of licensees enrolled in the group program and have had really good participation from the Tennessee licensees. We partner with Continental Casualty Company, which is a CNA company, to offer its E&O programs, and we handle the claims that are made against the insureds out of our office. Most licensees think a claim will never happen to them. However, over 20,000 real estate E&O claims have been submitted to Rice since 2003. And the reason I use the 2003 is that's when we started writing with Continental Casualty Company. And over 3,700 of those claims were in Tennessee. Those numbers are current as of the end of the year 2019. Continental Casualty has incurred more than $149 million for damages and claims expenses on behalf of the licensees insured through our program since 2003. Over $25.2 million have been paid on closed claims in Tennessee, and nearly $3.5 million have been incurred for open claims that are still ongoing. Now, you've been provided with a copy of the group policy claims information for fourth quarter 2019. That's the single page that I gave you. This report includes data for each policy since 2003. It shows the number of claims that are reported each year and the number that are currently in open open and the currently closed for each year. It also shows the total incurred amount per year on this report. This report shows each policy number, and then it lists the closed claims count, the total paid for closed claims, which breaks out the lost payments and the legal payments. It shows the open claims count, the total incurred for open claims, which breaks out the lost payments and the legal payments. Then it gives the total claims count and the total incurred amounts. Since real estate E&O claims typically take years to close, for example, we still have open claims from all but 2 of the policy periods since 2003, the true cost of the claim cannot be determined until the claim has actually been closed and all the related expenses have been paid. As a general rule, the claims that take longer to close typically cost more, and that's in part because the legal fees continue to incur until the claim is actually closed. It's still unclear if the amounts paid out for the more recent years will be more or less than the prior years. An actuary will look at the loss history and apply factors for continued development in order to calculate the premium that's needed for the program for future years. And then as the claims mature, the loss data is more reliable. So we will know more about the current period as time goes on. This is the second year of the 2-year policy period, which started in 2019. The claims count at the end of 2019 was 245, and as of March 5th, when I ran the last reports, the claims count was 314. So we've already had more than 69 new claims in Tennessee in 2020, which is basically, it's like a claim a day coming into our office. You'll note that we spend more on legal fees than we do on loss payments, and this is typical in this type of business. One of the most valuable features of the real estate E&O policy is that it provides defense cost coverage. There's no limit on the amount of defense costs under the group policy, so the amounts that are paid are in addition to the limits for damages. So if you have a $100,000 limit policy, that means $100,000 that's available for payment of losses, payment of damages. It does not cap the legal fees that are paid for that claim. Please note that these loss reports that I've given you today do not include any IBNR. That is a factor that's used by actuaries to determine the incurred but not reported claims, or the loss development. That's a factor that's used by the actuaries to determine the ultimate loss incurred. So they apply different factors to see what it's actually going to cost. When we first get the claims in, we set a low reserve because we don't know anything about the claim. We don't know if there's any merit to the claim. Until discovery's actually done, you can't get any real numbers that mean anything. Once discovery's done, then you go through, you learn more. Sometimes you find out when you go to mediation or when you go to trial that it's a completely different story than what they've told you all along, and all of a sudden you have to change those reserves. So when you look at the reserves, remember that's a fluctuating number. They can go up or down. But typically, the longer they're open, they typically do tend to go up. Also note that these loss reports don't include any administrative costs. That's the cost of the insurer to provide the program, including their staffing costs, their expense allocations, the administration, the marketing, the staffing costs, for our agency, and the claims adjustment costs that are incurred. All of these factors are determined when you're looking at what should the premiums be for a program. Overall, the amounts paid for the Tennessee program from January 1, 2003 to December 31st, 2019 for closed claims are $25,232,658. The incurred amounts and that are paid and reserved for open claims is $3,453,487. The total incurred amount for the 3,787 open and closed claims in Tennessee since 2003 is $28,706,145 at fourth quarter 2019. So this really shows the dollar impact of the insurance program for its purpose of public protection relating to Tennessee real estate transactions since 2003. When people are shopping for insurance coverage, I always tell them that it's important to ask the company's experience and their paid claims amount in their state, because if a company's charging a low amount, you might find out that their carrier doesn't provide much coverage or pay many claims. And when people tell me that they think that insurance companies don't pay claims, I tell them to look at our loss reports because we're paying claims in Tennessee. We looked at the claims in the past 7 years in more detail to kind of see what the recent claim experience in Tennessee tells us. I have provided you an exhibit that shows you the number of files per policy period, and this is in the green multi-page handout. There have been 1,602 claims reported under the policies from 2013 through March 5th, 2020. The number of claims for the current policy period appear to be up from other policy periods. There are 300 more days in the current policy period, so if the claims continue to come in at the same rate, we will have quite a few more claims in the current policy than we've had in some of the past periods. We also hear from many insureds that they believe that only a lawsuit can be a claim, but this is not true. Some emails, letters, and faxes can meet the definition of a claim under the policy. The group policy defines a claim as a written demand for money or services. You have an exhibit that shows the type of demand for the Tennessee files. The largest percentage of the claims reported during this period did involve a lawsuit. 744 were lawsuits. That's 46%. 527 were not lawsuits, but they still met the definition of a claim, so that's 33%. There were 285 regulatory complaints reported. A regulatory complaint is not a claim under the policy, but the policy has supplemental coverage where it will cover up to $5,000 for the defense of most regulatory complaints, up to $10,000 maximum per year. 212 were regulatory complaints only. 49 were regulatory complaints that were accompanied with litigation. 24, which is 1%, were regulatory complaints that were just accompanied with a written demand. In addition, there were 44 subpoenas reported because the policy provides limited coverage for attorney's fees if you're served with a subpoena for documents or testimony arising out of your professional services. In that case, the insurance will provide an attorney to provide advice and recommend you so that that doesn't get you into trouble later. And then there are also 2 arbitration claims. On the next page, there's an exhibit that shows the type of claims that were made. We looked at the type of claimant making the claim against the licensee, and the majority, 53%, are brought by the buyer. Some of the claims were brought by claimants that didn't really fit into a classification. 14% were brought by a seller, 7% were brought by the lessor, and another 7% were brought by the lessee. And then there were some other listed categories with small percentages. Next, we looked at the deal type for the type of transaction that gave rise to the claim during the period. The majority, 54%, arose out of a sale. There were 196 property management claims, which were 12%, and 171 contract claims, which were 11%. And then there were some other lesser categories that are listed on the exhibit. Next, we looked at the real estate type. 1,122 of the claims involved residential property. That's 70% of the claims. Because a lot of people say, well, I just do residential, but residential claims, there's so many residential transactions going on that, of course, it's the majority of the claims that we see. 87 were coded as managed property, 57 were not classified, 84 involved vacant land, 71 were commercial, 47 were condos, 29 were apartments, 25 were farms, 15 were bank-owned properties, 15 were mobile homes, 7 were multifamily residential buildings, and 5 were other. 4 were businesses, and 1 was a timeshare. We're happy to offer this program with affordable coverage and valuable protection for the majority of the licensees in Tennessee. Unfortunately, a licensee can sometimes do everything by the book, but they still find themselves faced with a claim when something goes amiss. Our society is becoming more litigious, as we all know, and this trend creates increased likelihood of a claim, even if the licensee has done absolutely nothing wrong. A claim can be disastrous from a financial, mental, and professional standpoint, and having adequate insurance protection is invaluable. In some states, real estate licensees aren't able to find any affordable coverage. Some licensees, particularly those who have had prior claims or are in specific fields, may not even be able to find a company that's willing to provide a quote for their E&O coverage. Since the Tennessee Group Program must accept all licensees at the same fixed premium for the basic policy, the mandated program assures that E&O insurance is available and affordable to all Tennessee licensees. In closing, we're very happy to partner with the Tennessee Real Estate Commission to provide this valuable program for its licensees, and we take our responsibility to the Tennessee Group Policy very seriously. If there's ever any questions that you have or even praise that you'd like to share, please feel free to call our office at any time. We'd love to talk to you. And at this time, I'll open for questions from the Commission.
Steve?
Question on the category. Would you think that the payouts track the percentage of category, meaning if you look at, let's say, residential at 70%, does 70% of the money going out represent residential, or is there higher percent going to another category that?
I would say most of the claims, since they are residential, most of the money's going to residential claims. But I have not conducted a percentage. I'll be happy to look at that to see if we can show the amounts paid out for each number, and I can share that with you all and send you an update on that information. But a lot of people think, oh, well, traditionally, the bigger dollar claims are going to be the commercial claims and the property management claims. But the fact that we get so many residential, you're going to see more of the pie paid out for residential, I believe. I would like to run the numbers before I give you that information. But per claim, on a per claim basis, the likelihood of getting hit with a large dollar claim is more likely if you're in property management or appraisal. However, we have a lot of big dollar claims that are residential. I looked at a few of the big dollar policy limit claims before I came here. One of the ones that stood out is selling the same property twice. So when you have multiple offers, everybody needs to be super, super careful on that, because there's many chances for misunderstandings of thinking that, oh, that offer's no longer valid, therefore you are the next in line and that your offer is good, and they end up having two contracts that they verified are valid, and you can't do that. So then everybody gets in litigation, and it gets very costly. But those have been, I think there were a couple of policy limits claims, and then they both had more than one licensee involved in them. So there were big payouts on both sides. And I don't remember if it was a listing agent and a selling agent at the same firm or at different firms, or if it was an agent and the broker that was also named. Maybe for lack of supervision, but those were some of the bigger examples for residential. We also see a lot of cases where the people sell the wrong lot. That's very common in Tennessee, because you've got some beautiful, properties with views, and the one that they sell is always the one that doesn't have the view. Oops, the one I thought I was buying was the beautiful one over here. We've even had one where I basically finished construction, and then the people pulled up and said, hey, thanks for the house on our lot. And it's not funny, but it's like, how can this happen? And it happens fairly frequently. In fact, in some areas, I'm kind of like, that happened to her before. Has she not learned her lesson? She needs to make sure that they're going out and getting a good, adequate survey before you go to the closing. But
other questions for Ms. Grisham?
I found it very interesting that timeshare was only one. We always have so many timeshare complaints here, so I thought that was very interesting that there was only one.
I agree, and I sometimes wonder if maybe they weren't completely coded correctly, because sometimes what happens when we get the claim in, when we first get it in, they code everything in on that document that comes in, and sometimes as you're learning more about it, you find out more about the claim. So these are not perfect reports, but they're what our system can capture. Just from coming to Real Estate Commission meetings over the years, I've heard lots of timeshare complaints, and I wonder if maybe they weren't always coding them as timeshare, because that's something we always do. We add categories as we go along. And I agree with you. I thought that number was a little bit odd, but that's what the report pulled.
Bobby?
I really got a comment and then a question. The comment was, I didn't realize this till I got on the commission, and you've already said it, and I just want to make sure anybody watching this video picks up on this, but at your company, if somebody gets a complaint from the Real Estate Commission, they can send that information in, and then your attorneys will help with the response to that.
That's correct.
And that's something I didn't realize, and that's a really neat thing. And so many times agents, we go, oh, we don't want to turn it into the insurance because it's going to ding my insurance. And I'm like, it doesn't work that way with E&O insurance. And so that's just something and so I saw you had those complaints laid out on this. But then the other thing was, and you and I have already had this conversation, and I just want you to put this on our video also, but it has to do with fraud and wire fraud.
Right.
And that we don't have coverage for wire fraud.
Right.
Within this program.
And something that people don't really understand very well, this wire fraud issue that's taken over our country. Wire fraud is really a crime coverage. E&O insurance is really designed to be for errors and omissions, but not to cover crimes. It has specific exclusions for crimes. It doesn't include fraud. It doesn't include, wire fraud. It doesn't include, taking of monies. But wire fraud is getting really exponentially, it's blowing up in our country. Like typically the email's hacked, and then the fraudulent email provides instructions on sending the wire to an account that is not the correct account for the closing, and then they come back and they want to sue the agent, saying that the email came from your office. Well, it didn't come from his office, but what that is that's a crime. That's a crime that's been committed. And true cyber coverage, covering that kind of crime, because of the number and the amounts involved, would be very hard to provide on a guaranteed issue basis for a group program for the licensees. But the main thing is that it's really truly not traditionally considered an E&O risk. It's considered a crime risk, and crime policies typically are with your general liability, which is a general liability policy basically covers for like advertising injury or personal injury, personal injury or bodily injury, things like that. So I always tell everybody, if the E&O insurance is the only insurance that you're purchasing, you're not covering all your risks, because there's a lot of things that that you need to make sure that you're purchasing to cover those other risks, and cyber is one of them. One of the things I've noticed is a lot of companies are coming out with cyber coverages, but you need to read them very carefully, because a lot of them, as far as the breach and notification duties, a lot of them will only provide coverage to a breach of the company's system. So most people are using their home computer system, their phones, things like that, to conduct their business if you're in the real estate industry. So that may not even be covered by that policy. And also a lot of the ones that they're touting as cyber policy, and people automatically think that includes wire fraud, it has exclusions for wire fraud. So if you're looking for cyber coverage, you really need to go to a specialized coverage to make sure that's what it's really providing. And unfortunately, we only sell real estate E&O insurance. We don't sell other types. We don't sell general liability. We don't sell cyber. We don't have any of that. We've looked at trying to offer some of those coverages because we have a great base of customers that would love to have that, but we have not been able to find a product that we were truly comfortable with, that we felt like we could say, this is what you should buy. And so as of this time, we don't have a product like that, a separate product to sell to you, which I wish we did, but I don't want to sell something that I don't have full knowledge of and full belief in.
But you do have like new home construction, you have property management, you have some.
Some endorsements, and yeah, let me tell you what endorsements we've got. The base policy premium, as y'all know, is $221, and that's for 2 years coverage, which is really shockingly low, if I have to say so. There's a conformity endorsement that basically provides coverage for your other states. Now, if you're licensed in Tennessee and doing business with a license in another state, it will provide coverage if you are domiciled in Tennessee for those other states. But the conformity endorsement, what that does is, for example, in Kentucky, they have a requirement of $1 million aggregate. So to meet Kentucky's requirements, if you're in Tennessee, you need the conformity because it automatically has language that says it will convert the policy language to provide the minimum provisions of that state's requirements for E&O coverage. That way, the policy you buy in Tennessee is going to provide coverage in the other states where you're licensed, where there are mandatory requirements. The other endorsements we have an appraisal endorsement and an appraiser trainee endorsement that the appraiser can purchase for their trainees. We have a contingent bodily injury property damage endorsement that basically only applies if there's no other insurance available. So that's very rare because usually there's the homeowners or something that's going to provide that. So I'm not a big proponent of that one because I just want people to know it's not providing all the coverage you think it might be, which is why we explain it when we're selling it, that it's only contingent if there's no other insurance that might apply. It might kick in, and it only gives $10,000 per claim. There's the property management endorsement, and that provides for anybody that's doing property management, and that kind of broadens the term of the professional services in the policy, and that's $100 for 2 years. There's the residential personal interest coverage. What this does is it adds coverage for the sale or listing of residential property, but it also has some very specific procedures you have to follow for it to apply. So I always tell people, make sure you read the endorsement and follow those because you have to have a home inspection and home warranties and things like that. That's $50. Incidentally, your sale of your primary residence is included in your policy, which traditionally was always excluded, but companies started putting it in, so now it's in our policy as well. You can also purchase increased limits. If you want to purchase higher limits, you can get $250,000 per claim with a $750 aggregate, or $500,000 per claim with a $1 million aggregate. And the price for the increased limits to $250 is $134 for 2 years, and the price for $500,000 is an additional $249 for the 2 years. We also have an underwritten program, which is excess policy that the firm can purchase that sits on top of the limits of everybody at the firm. But that's individually underwritten, and the pricing is based on the type of business that the firm does. Then we also have an endorsement bundle, which has five additional endorsements. That's $30. It has security breach notification, and that's $5,000 per real estate firm for costs incurred to notify clients if there's a security breach. Increased fair housing and discrimination sublimits, it takes it up to $50,000 per claim with a $50,000 aggregate. Increased regulatory complaint, which raises it up to $5,000 per regulatory complaint. Increased lockbox, which takes it up to $50,000 per lockbox claim. And increased subpoena assistance, which takes it up to $5,000 per subpoena.
Okay, Cindy, thanks for the report. Is it okay with you if some or all of this PowerPoint presentation be included in the minutes?
Sure.
The staff may want to take a look at it and might want to clean that. Might look like an advertisement. I don't know.
Oh, yeah.
But for the record.
We don't want that.
For the record,
yeah.
This Real Estate Commission has nothing to do with selecting Rice as our E&O carrier. It's done by the purchasing department with the state of Tennessee. So we appreciate the professionalism, the fact that you're so accessible, and that you take the time to come down and give us an update occasionally. Thanks very much for that.
Thank you.
All right.
Nice to see you.
Thank you.
All right. Mr. Ross White?
Yes, sir.
I get the sense that among some commissioners here, they would like for the chair to pick up some speed. Don't know if that's correct, it's just a sense I get.
You are correct.
Mostly from the chair.
Well, sometimes I speak for myself. Mr. White, let's go to your report. Let's talk about the courses first.
All right, Mr. Chairman, members of the commission, and greetings to our new commissioner, Mr. Gwynn. I want to call your attention to the March education agenda, specifically M1 through M32. Those are all the courses I've reviewed. Several new providers and instructors are included for your review and approval this morning.
All right, let's get a motion to approve M1 through M32.
So move.
Is there a second?
Second.
Ms. Torbett seconds that motion that Mr. Wood made. All right, now, are there courses that any commissioner would like pulled out of that motion? The motion, by the way, was to approve M1 through M32. Any courses to be pulled out?
I'd like to pull out M14, please.
Okay. Just for the heck of it, I'd like to pull out M1.
But I know why.
All right, the motion on the floor is to approve M1 through M32 with the exception of course M1 and course M14. If you're in favor of that motion, please vote aye.
Aye.
If you're opposed, vote no. That motion passes unanimously. All right, M1, Mr. White, quickly, that's a 5-hour course to teach you how to measure a house. Does it take 5 hours to learn how to measure a house?
That's what I could assume from the documentation and from Agent e-learning, the provider. They also provide a similar course, of course, for our sister agency, the Appraisers Commission.
They have the same course for appraisers?
Similar course.
Is it a 5-hour credit as well?
I do not know if their hours are the same as ours.
Is this with a tape measure or with a machine in a room? Do you know? Or is it both?
I'm assuming it's both. I don't know that.
Question, is there a standard, do you know, that they're using to measure a house? Like in,
Commissioner, that, as mentioned in the comment there, ANSI is the standard, and that's a residential building code standard that's adopted throughout the state and throughout the United States.
Oh, you can't answer my question. However, you think this course meets the requirements to be approved for 5 hours?
Yes, sir, it does.
I move that M1 be approved.
Second.
Motion by the chair, seconded by Mr. Wood, that course M1 be approved. Those in favor of that motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Ms. Franks, M14.
On M14, there was no instructor listed. It only says previously approved.
It's Mara Neal, I believe.
From the one above?
Yes, ma'am, I just didn't propagate it down below.
Okay, move to approve M14.
Second.
Motion by Ms. Franks, seconded by Mr. Wood. Discussion, I hear none, let's vote. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. All right, instructors.
Instructors, Mr. Chairman, I have two on your iPads there, 2 pages of, and 5 total instructors.
Your recommendation?
I recommend that the commission would approve these based upon their submittals.
All right, is there a motion to accept the education director's recommendation?
So moved.
Motion by Ms.
Second.
Torbett, seconded by Mr. Wood, that the education director's recommendation to approve these 5 instructors be approved. Discussion? Anybody want to pull one or more instructors out? Let's vote. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Thank you, Mr. White. That's a clear, succinct presentation.
Thank you, Mr. Chairman. I have one quick thing to bring to
Oh,
your attention.
now, I take back what I just said.
This is a short discussion item.
Go
but-
get your keys out.
Yeah, okay.
But as of yesterday, I received a request from one of our providers that, because of their constituents being concerned about the coronavirus, they teach a pre-license course, and they would like the commission's approval, if needed, that they could put the course on by the application Zoom, that the folks could actually do that online. Now, this is a classroom course. It's not an online course, but all they're saying is, if needed, as a good contingency plan, they're already teaching the 60-hour course, so they're already into it, and they've been there, I guess, a few times, but prior to, because of this has come on and fairly rapidly, they would like to know if it would be all right with the commission that they do that.
So I'll ask a question. What is Zoom?
Zoom is an application that folks can work from home on, and then they can, let me read you what they described it as. Let's see.
We do all of our Arello Executive Committee meetings on Zoom, and all you do is you go on your computer and you connect with it, and it shows you you can see up to 5 faces at a time. So a teacher wouldn't be able to see everybody's faces, only 5, and they kind of circulate. But you have a camera with, facing you. It's been very good for a small group like an executive committee. I just don't know how well that would go with
30 people.
30 people.
Well, the technology, according to the provider, can tell if the students are in attendance, so they could keep accurate records, and they could also ask questions in the chat function. So I'm not sure about the limitation on the 5 or 30, but
There's no chat, and when we actually do, we talk back and forth, and there's not just a chat section to it. But I can see how, if there's only 5 that you can see, then 25 could.
To me, this is
Go to
more
town
of
or
a policy question than a
Yeah.
single provider request. I don't know if it's something, the topic this commission is comfortable putting on next month's agenda, or if you want to add it later today to talk about.
Maybe everybody could look at Zoom and see what they think.
But we already have classes that you can do this way. We have internet classes.
Yeah, but
He's just wanting to convert a classroom class that approved to an internet class.
the only thing he is espousing really is that because of the coronavirus, he says, I'm concerned, we just want to have a good contingency plan. And so that's what they're presenting. It's really a classroom course, and it's approved as a classroom course. But so that these folks and their customers get their money's worth, they just want to be sure they can help
Who's
them
the
complete
school and who's the instructor?
CLI is the school, Continuing Learning Institute, and it's questions coming from Mr. Mike Easterday.
I'm going to do what Bobby Wood does. What are you going to do, Bobby?
I'm like, if we start going down this road, then we're going to have to start making contingency plans for the flu and the cold. I don't think I want to open this door.
Neither do I.
So.
And I don't think that
We
requires
heard
a
you,
vote
thank you.
even.
Yeah.
All right. Thank you, Mr. White. Thank you, Mr. Wood. Ms. Maxwell, where do your report?
Okay, I will definitely keep mine quick. Just wanted a couple updates. Last month, Commissioner Wood had asked about the increase in sanctions, and it didn't initially occur to me when you mentioned that, but just wanted to follow up that those are from E&O. The penalties started hitting in March, and so those are related to 80% of our licensees, E&O, expiring at the beginning of January of 2019. So you're still kind of seeing that increase all the way sort of until September. And then I mentioned this last month, but as of January 2020, anyone that has been without E&O for a year is now revoked. So a lot of that increase is due to people paying their E&O penalty. Also wanted to mention the May meeting. We will be meeting in Jackson, so we've gotten the rooms reserved for that. We're going to be staying at the same place as last time, which is the Hilton Doubletree in Jackson, and then the meeting will also be at the City Hall as it was the last time. And that is on a Thursday and Friday. I believe it is May 7th and 8th. So just wanted to mention that. We'll obviously be sending out more formal updates. All the paperwork has been submitted for the mid-year for Arillo. So as of now, we have Bobby and Jeff going along with the staff, and then we have Joe as a backup. The other item...
Can I ask one? So I looked on Arillo at the list of commissioners from the state of Tennessee. We need to update that list because there's some people not on here now, and then we have new ones. And they have to be on there or they're not going to be receiving the Boundaries newsletter that tells you what all is going on in other states and at Arillo.
Okay, yes, we can definitely update that. So that's primarily what I had. I think legal might talk a little bit more about this, but we do have a formal hearing set for April, as well as we will be doing the rule review, the formal hearing for the rules. That will be on Wednesday, and then the formal hearing would be on Thursday.
All right, so for those of you who've never participated in a formal hearing, on your calendar, you need to reserve 2 days. But be aware that there's a chance that at some late moment, the respondent might suddenly agree to what was offered to them, or they might ask for a continuance, and the administrative law judge might give them to them. So I'd make sure you have 2 days on your calendar, but don't be disappointed if, like, the Friday before the Tuesday you're getting ready to come here, it becomes only a 1-day meeting. And I know legal will let us know if something like that happens as quickly as you can. We'd appreciate that. All right. Any other questions for Ms. Maxwell? And you can reserve the right to ask her any question you want through the entire meeting, but if there at this moment none, we'll move on to Ms. Frank's request to talk about licensing requirements.
Okay. In the past a couple of weeks, an issue arose in my office that I've never heard of before. We had someone buy home from us who has a California license, but she lives in Las Vegas, and she's buying a home from us, but she's getting a Tennessee real estate license. And so we do not do facilitator, and we don't do dual agency at my company. So I took the position of representing that buyer. So I got information from her that she had decided not to move here, but that she was just going to turn this house into a rental, but she still wanted to get her commission. And I said, well, as soon as you get your broker's license, we can do that. And not broker's license, but affiliate license, we can do that. I got to thinking about it, and I'm like, wait a minute, she's not moving here? And so I looked it up, and it's very clear in our book, in the law. On page 28, it says, one of the requirements is that they have been a resident of this state for at least 45 days. Now, I quoted this to her, and she says, no, that only applies to brokers. And so I sent her a picture of it and said, no, it's I told her I'd be glad to represent her, do a referral or something else. But she said no, that she had called the commission, and the commission says that we do not follow that law, that she can still get a license. And so I'm like, what? So I called Anna, and she wasn't sure about it either, and she thought maybe it had something to do with the Safe Start Act. But when I look at the Safe Start Act, that's only for criminal...
Fresh Start.
The Fresh Start, what'd I say?
Safe Start.
Fresh Start Act. That's only for, it only pertains to people who have previously been criminals. So I'm not sure why we're giving affiliate broker licenses to people who live in Las Vegas.
Well, a couple things.
And she received her license. She has been licensed.
Yes, yeah. ever since I've been with the commission, that has been the practice, that we allow out-of-state individuals to become licensed in Tennessee. There's also...
Oh, wait, with that statement right there. So, who told you that that's what we do?
Nobody told me. We've been doing it ever since I've been with the department.
So in your orientation, they said, we don't follow that law?
I think I could pull a listing of all people licensed in Tennessee, and you would find a large amount that are not Tennessee residents. There's also another statute, I'll find it under reciprocity, that says individuals can become licensed as long as they meet the requirements or greater. So there is another one.
But I thought we didn't have reciprocity in the state of Tennessee.
So we do not have reciprocity, but our law does say that you can use requirements that you've met in another state as long as they're equal or greater to ours. So that's not word for word. I'll find it for you.
But that has to do with the education. That doesn't have to do with the living here. Because in your point,
Yeah,
it says here that they got to
should
live here.
Reside in the state for at least 45 days.
There's plenty of agents. I think it would be
Just
really...
because it's something we've always done, doesn't mean that that's something we need to continue doing if it's outside the law. And if it is outside the law, and this is, I mean, it's very plain to see here, I'm wondering, because I was frankly embarrassed. She knew I was a real estate commissioner and really challenged me on it. And said she called and she was told that I was wrong. So I would like to know what other laws, in addition to that one, are we not following? I thought we were to follow the laws, not do what we've always done.
So we have a section there related to non-resident licensees. And I don't think there's anything in that section that says you have to live in Tennessee for 45 days before you can be a non-resident licensee.
This does right here.
And I certainly could be mistaken.
I don't, it's not my call whether it's right or not. I don't go up there on the hill and make the laws. So we can't change it.
So Section 314, if you're on your book, it's on page 38, talks about reciprocity or service of process on non-residents. And so it says if a non-resident of the state who is a licensed broker or affiliate broker equivalent in another state, you are allowed to apply for a license here by submitting appropriate application issues. So I understand your concern with the 45 days. That is a bigger constitutional concern, which is why it has not necessarily been something that we have been enforcing. It's one of the things that we look at is whether a law or a rule is considered to be anti-competitive. And requiring an individual to reside in a specific state when they have a license in another place gets you into some real constitutional concerns by preempting an individual.
But we didn't make that law.
I understand, and I know that's not something that we made, and it's something that's here in the statute, and something that most likely needs to be addressed. But the practice has been that if you are not, we cannot bar someone from a license just because of residency requirements. We license individuals.
Where is that in this book? That we cannot bar them for residency requirements?
It's not in this book, but it is a constitutional, like United States constitutional issue. And so federal law preempts states' laws. And so it gets, like I said before, it's a constitutional issue, not just a real estate commission statute issue, which is why this has been, I guess, generally the practice beforehand. So what I can do is go back and look at this, figure out what's going on, because I'm sure that other commissions have the same language and they have the same practice, but I'm not exactly sure. It may be, most likely be, that we need a statutory change that would rectify this. But as of now, I don't think that there is an issue. It's just we don't want to get into the habit of denying an individual licensure based upon where they live and place residency requirements, because like I said before, there's a larger constitutional issue in anti-competitive, restricting trade, and that type of thing.
But you can make the argument that by saying that real estate agents have to have at least a high school diploma or a GED, that's restricting competition too. But I think the determination has been made that maybe that level of education is needed to do what we do. And I think a person can make an argument that it sure is a lot more helpful to sell a piece of property when you live in the vicinity.
Education and residency are completely different constitutional law issues, and you could make an argument, but it's not going to be the same as requiring someone to live here. It's not even on the same level.
I think instead of you asking an attorney from another state what their opinion is.
I'm not asking an attorney from another state.
Well, you said from other states, you would get what,
No,
find out
other
what they're
boards.
doing.
Other boards.
From the other boards here.
Okay, I would love for us to get advice from,
AG.
yes, the Attorney General's office.
Just curious how that would work in our area. We're in Northeast Tennessee, and I mean, I'm miles from Virginia and North Carolina, and I think it would present a different issue up there, because I'm sure there are plenty of people that live in Virginia that do real estate business in Tennessee. So is there an exception?
It's an interstate commerce and trade issue. Like I'm saying, I will look at it beforehand, but I promise you that most likely the same answer is going to be given to you, that if this is in conflict with the federal law, that federal law preempts our state law, and which is why we're not necessarily adhering to what the statute says here. But I would like to check on the answer first before we go to the Attorney General's office, because I may be able to get you an answer faster, and I'll have that information available for you in April.
That'd be great.
Great.
That'd be great.
Great topic.
I would point out, too, I think in Memphis, we probably have a lot of agents with licenses in Tennessee that live in Mississippi. Mississippi's a suburb of Memphis, and they probably don't even have their Mississippi license.
A couple of years ago, we had to address the education requirements, especially between Tennessee and Mississippi, because the Memphis people brought it to our attention that they weren't taking any education in Tennessee, but they were licensed. So this person that lives in Las Vegas, they'll have to have the 16 hours of education and the core class, right?
Correct.
Okay.
Or comparable classes in.
They have to have classes that have been licensed in Tennessee.
And it has to be a Tennessee core class.
Yes, yeah. The classes have to be approved by the commission.
And I can tell you, there's a big task force we've had for 2 years at Arello that's looking at license portability, where everybody, I can sell in Las Vegas if I want to. And there is a huge movement for that and a lot of people for that. I personally am not, because I agree with Bobby. Yes, we all have internet, but I don't have knowledge. I can't be an expert on property in Franklin, Tennessee, when I live in Las Vegas.
Right.
So, but the other thing too is, if there's anything else that I hate to have to call Anna. I've had to call her twice this month, but if there's anything else that you're reminded of, Anna, like when you're looking this up, to let us know about, because I would rather know beforehand than to look like a fool to this person.
I'll let you know for sure.
Okay, the second topic you wanted to talk about was searching for principal brokers.
Yeah, so I'm sorry, Caitlin. I just wag on this all the time. I needed to look up a Keller Williams broker, principal broker. And when I went to Keller Williams licenses in the state of Tennessee, I couldn't tell what was what. They have the DBAs that don't even get me anywhere. What I was looking for was the principal broker name. Still, we need that desperately. As a principal broker, there's I know 3 of us at least that are principal brokers up here, and we need that information, and I get people complaining about it all the time.
I've had conversations with our IT and admin, because they're currently, that's something that's in the works. But it is these kind of things are large contract changes to our existing licensing system. So it's unfortunately not just something I can snap my fingers and change tomorrow. But it is something that I've
It's been
requested.
6 years that I've been
Wow.
asking for it.
I can only speak for the last.
I know. It's not your fault.
Yes.
I know that. It's not your
Yes.
fault. But
It
just
is-
please, I mean, it
Yes.
is, I mean, when you have to give them a priority list, this is a huge priority for licensees in the state of Tennessee.
Point
That's all.
well taken. You're not the only person who's talked to her about that.
I know.
I don't want you to think you're the only one.
I know, I'm the one that keeps bringing it back up.
Yeah, I don't want you to think you're the only one. Who keeps
I know,
bringing
I'm
it up.
not.
All right. Let's do these medical waivers, and we'll take a quick break or talk about lunch or see how you guys want to proceed. Caitlin?
Okay, these are a little odd, but they're not our typical medical waiver request. But they are two individuals that reached out, and I thought would be appropriate to bring before the commission. Both of these waivers are related to the E&O penalty, and both of them submitted medical request stating that it prevented them from maintaining their E&O. So I guess we'll just go in order here. Rebecca Rains is the first one. And I have drafted it the same as our medical waiver request with her license information, her letter, and the doctor's note.
And I would like to add that her real estate company is in Trenton, Georgia, for everybody. I'm highly sympathetic to anybody who's had cancer and chemo and understand that causes lots of lapses. She's asking for $1,100, and she's been revoked, right?
Yes.
And she's a broker. And so when was she revoked?
So, and I looked at this because, you would say, well, how, their license. So she would have renewed her license, and we did not suspend licensees until the end of January for E&O. Just with, the holidays, we wanted to make sure that we had accurate data of everybody that had E&O. So she would have renewed, and then shortly after, her license would have been suspended due to E&O, and then after a year of being without E&O is when we revoked. So she would have been revoked as of the end of January.
But her license was active all this time. She just didn't have E&O, is that
No,
right?
it was suspended due to E&O.
And she completed her chemo in November of 2019.
I'm thinking, did she have an active broker at the time that thought that she was with them? I'm like, where's the broker in this?
In Georgia.
Well, no, I mean, as a broker, I keep up with if my agents have an active license or if they have E&O. And why didn't the broker catch this?
Let me look it up in the system.
Found that Dora Chris Realty is, they do business in Tennessee, Alabama, and Georgia. I suppose they're right there at that little connection point. And does it mean that now that she's revoked, that she would have to start over?
She is the principal broker.
Oh.
So all communication related to the suspension would have gone to her as the licensee and the principal broker.
She owns that company. She owns the real estate company. I didn't know she was principal broker.
You wouldn't have known because you couldn't see it online.
Right.
Is what it was.
I'm confused on the numbers. What is she asking for?
She is asking for a waiver of the late penalty when
Which is how much?
$1,100.
So $1,100. How much is the fee with no penalty? E&O.
So if you maintain your E&O, you're not paying us.
What
You're
is
paying.
her? She's got to pay some. What is
$212.
$212?
No, it could be a lot less than that, depends on where primary license is. Like I'm licensed in Kentucky, and it costs me about $10 for a conforming policy in Kentucky.
Let's say, okay.
But, Ms. Grissom, her policy in Tennessee would be $212 if she got it from you all, right? We don't know that they got it from
That's true.
that, though.
So
They're usually more, though.
The 1,100 goes to the state of Tennessee, and the 212 goes to Rice, and then she's square if she pays.
That's assuming.
1312?
She goes to, right, she could get it somewhere else.
Could
too.
get her own.
Yeah.
Right, but let's say you use, okay,
212 would be the cheapest you could get it for.
right. So 1312, and then she owe a license fee as well? Is she, or she paid that?
This is the penalty. Isn't it like $100 a month or something, or? I mean,
Yeah.
It's just a penalty for
Yes, yeah,
being
her
late.
license does not expire. It's obvious, it's not in an active status right now, it's in a revoked status. But her license, assuming she got it out of revoked, would not expire until 1/5 of 2021.
And we don't have that information on our iPads.
It should be on this medical waiver request.
It was in our document sent to us, but
Oh,
So basically, is she saying then that she couldn't pay 212 to avoid paying 1,100?
she is
Correct.
saying essentially that when her E&O expired last year,
But all she had to do was pay 212 not to have that happen, correct?
correct.
Okay.
she just said due to her medical condition.
When was she should have paid that by?
So
Would that have been
everyone-
December
um,
of 18?
So she, I believe, her E&O expired on 1/1/19, and we gave individuals, we notified them on 1/31 that their license was suspended due to not having E&O.
That was
And
that
then
was
they're
6
given-
months before she went into treatment.
Yeah, I see where you're going.
She went
Her
into
treatment
treatment
didn't
in
start
June
till
of
June.
19.
Yeah.
So she was sending, and you weren't receiving back undeliverable, or did we send her anything?
Yes.
Is it letter or?
Yeah, a letter goes
Okay.
to the individual, their firm, and their principal broker.
Yeah. Where you want to go, Bobby?
I'm going to be a bad guy. So her license is not active right now, right?
It's in a revoked status.
And so her company is operating without a broker.
Well,
It's not licensed state of
Yeah.
Tennessee.
her company is operating with the broker that's revoked.
Is Dora Chris Realty have a firm license in the state of Tennessee?
Yes.
Okay. And so
no
we
principal
know
broker.
that she's
Yeah.
still down, who's down as their principal broker at this moment?
Her license is still.
Okay, I don't want to go there. Okay, I'm not, and her problem occurred before she went into treatment. I mean, she's wanting to use the treatment. I have great empathy for people in this situation, but the problem occurred with her license for E&O before she ever went into treatment. And so, I mean, I guess I'll be a negative motion. My negative motion would be not to waive the penalty.
Second.
Okay, the motion offered by Mr. Wood and seconded by Ms. Frank would deny the request made by Rebecca Raines, although in the letter from the School of Medicine is Rebecca Birchfield. I would assume that's the same thing.
She might have gotten married.
All right, any discussion? Let's vote. If you're in favor of denying the request, please vote aye.
Aye.
If you're opposed, vote no. And motion passes unanimously. Mr. Woods, Ms. Maxwell.
Okay, this is a similar situation where Mr. Woods allowed his E&O to lapse, and you should have the medical waiver request. He is asking for a penalty waiver of $1,000.
He's paid it already.
Yeah, he's already paid it, so this would be a refund.
And this was a broken leg, a severely broken leg that caused him to be in the hospital for 2 years, right?
Why was his penalty 1,000 and her penalty 1,100?
He did get E&O at the beginning of this January, and he's already paid it.
Each month, that penalty's a little more.
Up to 12 months. All right, Mr. Wood, you seem to be down on people today. What do you want to do?
That is not true.
He has a good heart.
But I feel different about this one because his issue started in 18. And so I feel different.
Well, then make a different motion.
I'll make the motion that we refund his money.
Second. Is there a second to that motion? Ms. John. So we got a motion and a second to agree to the request of James R. Woods. And the state, if this passes, will refund $1,000. Discussion? Let's vote. Those in favor of that motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. All right, members of the commission, we're going to, at the very least, take a short break. What time is it here?
11:41.
11:41. So the question to commission is, you want to work through lunch, or do you want to take a break for lunch? Are you ambivalent?
Are there places around here that...
Let's keep going.
There are no quick places around here. We need,
Okay, so the chair has assumed, based on no discussion, that we're going to keep working, and maybe in an hour at the late, we might change our minds and take a break. But let's take about 7 or 8 minutes right now, and then we'll get to the legal report.
and there are some snacks in the room across from the bathrooms, if you need a snack.
It's not a bad.
Across from the bathroom. Oh,
That-
you mean at machine?
There's some
room behind.
right there.
I'm assuming.
You go around.
Oh,
other
you're talking
side.
about the Coke machine.
Yeah, the Coke machines and,
Oh, we got some.
There's stuff.
yeah, there's still some stuff back here too.
Yeah.
I say tell the real estate commission, get
I
out the
think we need to-
checkbook and bring some pizza.
I think we need to order delivery dudes.
What if we bring the food in and work through lunch with food?
Can we get,
Can we do that?
hey, I don't know why. It makes it very hard when you haven't had breakfast. I've had half a bar.
Well, I had
We used to
cheese it.
always go to lunch, but we do it for the ones driving so
I
far.
don't mind to go to lunch if it's because of us driving. What about you, Joe? Do you need to get back?
He's the one that likes to get
Cindy,
back.
we're gonna start doing like real estate companies do. We'll invite somebody to come talk, but you have to bring lunch. That's what we're gonna start doing. That's what we'll do.
Knowing her, it would have been a good
Yeah,
one too.
we should have gave her a heads up on that. I would love to do something like that. Just
Or
get in here.
sandwiches. Just have
Yeah.
something brought in.
Yeah, I'd love to do that.
The way I'm looking at
Oh, in Gallup.
We've Not a few hours.
Yeah.
I would think.
Yeah,
we're
we
gonna-
got a
I can
couple
only
more
so
hours at
many
least.
pieces.
Yeah. There's all kinds of stuff to get delivered around here. If they don't know, my wife's down the street and she could tell us. 'Cause they get stuff brought in all the time.
We've got.
The last meeting comes back in
So
here.
this is just the year end of 2019. So we've got June.
Our first instructors was
Yes.
John Grease, the chairman.
So this is half
He was a
of the
great
cost of
teacher.
the year.
He actually
There's
was
probably
a
still going to be claims. for it.
I've learned a lot. I've learned it. I don't want to come up before you guys. Tough.
Well, listen,
2020 claims.
I've learned more being on the commission and hearing stuff that people try to get away with. I just.
This one has, this
They're online if you up to during.
that's what's, it's way it works. Problem is, a lot
There was an address.
Those numbers. That goes. By those.
Rest of his.
Thank you.
it was a pleasure.
Yeah.
Nice to see y'all.
Good to see you.
It's fun.
Yeah.
Good to know
Thank you again for the,
It's fun. It's nice to get
that's
to see
nice.
you. Yeah,
Yes.
I was glad to get,
Yes.
glad to be included. And I will be, and so. Bobby and
Marcia, maybe?
Marcia will be there for sure.
No.
Well, she has to be because she's like,
Okay.
she's like Madame Morello.
Oh, okay. All right.
Well, it's good to see you.
Good to see you. Thank you. Uh-huh.
Good to see you.
Great job.
Yeah, I was like, you do the math.
Can't have that.
I'm like, I don't have to get a haircut every 2 weeks and spend
John Grease. John Grease, I have some things for you.
Really, like gift cards?
No. You will need to recuse yourself on number 9 and 20
Is that the consent calendar?
on the legal.
My signature.
Read the line next time where to sign.
Bring me some.
Take this over. Biggest surprise.
Delivery. And if we wanted to get food delivered here, how would we go about doing that?
So I do that like all the time. So I just put 500 James Robertson Parkway.
So do you do like Uber Eats?
It depends on the day. So Uber Eats, Postmates, and DoorDash. So they'll deliver here. I usually just tell them, meet in the lobby or meet in the front of the building, and they'll bring it.
So what else close by here that you like to order from?
Like what food places?
Yeah, that's reasonable distance from here.
It just depends. Like literally, most things, if you put in this address, will come here.
I don't know, we're just discussing our options of if we wanted to break for lunch or just have lunch brought in, so. I don't think we've gotten that far yet.
Sushi. We're kicking that idea around.
I'm booking a last-minute spring break trip to Fort Lauderdale.
Are you really?
Yeah.
Just got back from Clearwater Beach yesterday.
There are cheap Allegiant flights out of Asheville.
Oh, they're cheap. I flew round trip, checking it, the carry-on bag. Round trip for $144.
For my daughter and me, and one carry-on bag is $228.
Were you leaving Asheville or Knoxville or what?
What?
Are you leaving from Nashville? Asheville.
Mm-hmm.
We'd have to get everybody's.
Sounds good.
Asheville usually has better flights, or it depends on where you're going, and honestly, it's about the same from where I live to get to the Knoxville airport. Drive going to Asheville seems to have more flights going to South Florida, I guess, because people alternate between the mountains and, the snowbirds down there.
So you didn't reserve a seat?
Did you get extra leg room seats?
So, I didn't. And when I saw what my seat was going to be, it was like a D seat in between people. And I want to keep my neck out, so I paid an extra $16
To get,
for an aisle seat. And when I sat down in my aisle seat, there was the biggest person that could possibly sit between A and C.
Oh, no.
C spilling over into my seat, and I thought, man.
Well, we're only
It was at the Allegiant flight?
an hour and 20 minutes off.
Got it. Okay. I thought that.
All right, y'all ready?
Ready.
All right, let's get the meeting back in order. We'll go to the March consent agenda. Must be two. See if she recommends that to you. Maybe some of you. All right, March consent agenda. Ms. Downey, appreciate your patience getting here early and listening through that. Would you read into the record the cases that you're handling on the consent agenda and then tell us your recommendations for each?
Absolutely. I'll start number 1, 2019-085171. Number 2, 2019-085011. Number 3, 2019-085941. Number 4, 2019-085751. Number 5, 2019-086831. Number 6, 2019-086401. Number 7, 2019-086971. Number 8, 2019-085681. Number 9, 2019-085701. Number 10, 2019-086181. Number 11 is 2019-086541. 12, 2019-086731. 13, 2019-086981.
14, 2019-088891, 15, 2019-089361, 16, 2019-088611, 17, 2019-089481, 18, 2019-090381, 19, 2019-091551, 20, 2019-091501, 21, 2019-091581, 22, 2019-092281, 23, 2019-092211, 24, 2019-093511, 25, 2019-094171, 26, 2019-094311, 27, 2019-094741, 28, 2019-095371, 29, 2019-097361, 30, 2019-097271, 31, 2019-097331, and 32, 2019-097751. And my recommendation for 1 through 32 is dismissal.
All right, let's get a motion on the floor to accept council's recommendation, then we'll see if anybody wants to pull cases out.
So moved.
Second. Ms. Torbett makes a motion to accept council's recommendation. Mr. Wood seconds. Now, with that motion on the floor, are there cases that individual commissioners would like pulled out? Mr. Wood.
2 and 4.
Other commissioners? All right. Let's vote on the motion, which includes approving council's recommendation on cases 1 through 32, with the exception of cases 2 and cases 2 and 4. Those in favor of the motion vote aye. Aye. Those opposed, no. Motion passes unanimously. Bobby, case 2.
Really, both of mine are more questions than anything. Number 2, it was the respondent is a timeshare or licensed timeshare resort, and it said they did not respond.
Well, since they filed this complaint and it was outside of the statute of limitations, they don't have to provide a response to us because it's nothing we could do anyway. But even if they did provide a response, I would have recommended dismissal simply because there wasn't anything that was done that was wrong. But if it's outside of the statute of limitations, we can't really touch it anyway.
Yeah, I mean, and I'm just trying to think through that. I mean, the answer was going to be they were going to get out of it, but they chose to ignore us. That's the part I didn't like. Because if you want to make that argument that we were going to win anyway, why do we need to respond? There's a lot of times on these consent things where the other side could just say that argument's so stupid, we're going to win anyway, why do I want to respond?
I don't know if that's what the thought process was for them. Sometimes when we get these timeshare complaints, the complainant might put the incorrect address or something. So we can only send it to the address that we have. So it's possible perhaps they didn't see it. But I do know that go ahead, Anna. Sorry, I wanted to clarify. Since I believe Kristen wrote this beforehand, we do have a response from the respondent. I have another complaint on my represent. This one particular company, we'll explain it later, but they sent their response to the wrong entity, but we do have a response in the file from them.
Then I'm fine. I move to accept council's recommendation. Dismiss.
Seconded by Mr. Begley. The council's recommendation be adopted and case 2 be dismissed. Those in favor of the motion vote aye. Aye. Those opposed, no. That motion passes unanimously. Number 4, Bobby.
This one was about the coming soon, and then my question was, did you, because they're saying that they got permission to basically, they get the listing but not tell anybody about it. Did you see the listing agreement, and did it have written on there somewhere saying that they were not they had the listing during the coming soon period, and in that it said don't make this available to everybody?
Let me pull up the file.
Because a listing would be required for them to do any advertising.
We'll even have a sign yard.
Give me 1 second.
John, I'm not opposed if we want to give Kristen some time and we can move on to Anna's stuff, if we want to do that.
That works for me.
Okay.
I'd like to thoroughly look through and
Okay.
make sure.
And my guess is it's probably on the listing agreement, and it's usually handwritten somewhere on it. But it just kind
I want to say that they have provided it, but like I said, I just want to look thoroughly.
Can we do that? Move on to Anna?
Okay.
33.
Number 33, 2019-095451. 34, 2019-096791. 35, 2019-097641. 36, 2019-088301. 37, 2019-088831. 38, 2019-088851. 39, 2019-089251. 40, 2019-089331. 41, 2019-090151. 42, 2019-090311. 43, 2019-090801. 44, 2019-092041. 45, 2019-092191. 46, 2019-092201. 47, 2019-092521. 48, 2019-093771. 49, 2019-095621. 50, 2019-095501. 51, 2019-095721. 52, 2019-095371. 731. 53, 2019-095741. 54, 2019-095761. 55, 2019-096271. 56, 2019-096281. 57, 2019-081631. And my recommendation for those 33 through 57 is to dismiss.
All right, is there a motion to accept council's recommendation?
Move to accept.
Ms. Franks makes that motion. Mr. Moffett seconds it. Is there discussion, or would anyone like to pull cases out?
I'd like to pull out number 42, 43, and 53.
What did you say, 40?
42, 43, and 53.
Okay.
Bobby, is it anything for you?
47, 48, 55, 56.
7 and
47, 48, 55,
Yeah.
and 56.
Thank you.
Right.
Okay, so the motion on the floor, unless someone objects, is that cases 33 through 57 be dismissed per council's recommendation, with the exception of cases 42, 43, 47, 48, 53, 55, and 56. You ready to vote?
Yeah.
Those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Ms. Franks, number 42, and maybe 43.
So number 42 was that they changed the title company. Plaintiff states respondent changed the closing title company, and they were required to pay closing fees they believed were unnecessary. What I'm wanting to know is, did the complainant agree to changing the title company? Was that in writing?
Yes, it was in writing. They had information from the other title company and they signed the paperwork.
Was that beforehand, before the closing?
Yes, it was
And they knew that?
beforehand.
Okay, I move that we dismiss number 42.
Second.
A motion by Ms. Frank, seconded by Mr. Wood, that case 42 be dismissed. Those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. 43. Marcia.
Okay, so this one said that the previous council stated to this person that that a real estate license was superior to a lodging license, and so they thought that they didn't need a lodging license. So my question is, they're two separate, just like if it was a contractor and a real estate, right? So there is no, that it's superior, and that they could do vacation rentals and short-term rentals underneath their affiliate broker?
No, like, so, before we got here, there was an update, and it was explained that if you had an affiliate broker license or a firm license, that would be all that you would need to do vacation lodging. And since we've been here, vacation lodging is separately, it's enumerated separately in the statute, and I don't believe that's the case. You need a vacation lodging license and a designated agent.
So you're saying that I could not do a short-term rental because I don't have a vacation lodging license?
If we're looking at the definition of vacation lodging, it would be 14 days or less. I think if that is like all that you're doing is just short-term rentals, you would need a vacation lodging license. But if you're doing a short-term rental, I don't think you would be required to have a separate license.
So then what are you saying about this one then on, it's been determined that vacation lodging licenses and real estate firm licenses are separate?
So ultimately, I think what this individual needed was a vacation lodging license, and I don't think it would be fair for the individual to be penalized for information that they received directly from us that was erroneous.
Okay, I got you.
If
Okay.
that makes sense.
Move to dismiss number 43.
Second. Motion by Ms. Frank, seconded by Mr. Moffett, that case number 43 be dismissed per council's recommendation. Those in favor of the motion vote aye.
Aye.
Those opposed vote no. That motion passes
So to be
unanimously.
clear, I can do, or anyone that's an affiliate or broker can do short-term rentals?
I think, especially since there's been the recent change, I think originally when vacation lodging, the chapter was written however many years ago, the intention was kind of those short-term rentals that are cabins and that sort of thing. And I think as technology has changed and other things have changed, people are managing short-term rentals for others, and it's not that original, like, cabins. And so we do believe that you need both.
So
Short-term rental, if you are managing short-term rental properties for others, and they're under that 14-day time that they're renting it, you would need a vacation lodging license to do that.
So the definition of vacation lodging service means any person that engages in business of providing the services of management, marketing, booking, and rental of residential units owned by others as sleeping accommodations furnished to pay to transients or travelers staying no more than 14 days. And so we've talked about this beforehand, whether it's a short-term rental, and that would be a property management, or if it is going to be considered a vacation lodging license. And I think here, for these specific facts, the individual would have needed a vacation lodging service license, but they did not have one, and that was because they were told incorrectly.
I understand the mistake that was made. I just want it to be clear for anybody watching this, because I think most realtors think that they can lease any property because they have a license in the state of Tennessee.
Right.
So you're saying that if it's a lease that's 14 days or under, they have to have an additional license of vacation lodging. And is there is there a test for that?
I don't believe there's a test. I know you have to complete 8 hours of education. But if that's something that we wanted to disseminate to individuals, like through e-notify or put in the next newsletter, that's something we can certainly do to make sure
I think that would be a big, huge, that's a big deal in Tennessee.
Okay, no problem.
Our major thing is tourism these days, it seems.
All right, Bobby, 47.
47, I think this was the one where maybe the seller had got a billboard or something, electronic billboard, and then when they listed their property, they put the agent's cell phone on it. Was that right?
No, so this was prior to hiring the agent, the seller had posted their own information on a billboard. And then they entered later into a listing agreement with a firm and an agent. And then following that, this complaint was filed. They didn't tell the agent about the list that they had an advertisement beforehand. And so once the agent was aware of that information, they took it down. I don't believe, if it says that it was it was just an out-of-state phone number, it wasn't the licensee's phone number, it was the seller's phone number.
Oh, okay. I got the impression that it was the agent's cell number they put up there.
No, I
Okay.
have no evidence to suggest it was the agent's cell
Okay.
phone number. I think it was their personal number.
In Las Vegas.
Okay, then I'm fine. If what you're telling me is right, I'll make the motion, we accept council's recommendation to dismiss on 47 and 48.
Is there a second?
Second.
Second by Ms. Torbett. Discussion, those in favor of the motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously, and both 47 and 48 are dismissed. All right, Marcia, back to 53.
I have written down here in my note, the cell number, not the firm number on this one. Was advertising, okay, this was on some social media, and they were advertising their cellular number. But the principal broker, is this the one that they said they had it at the bottom of each page? Because that's what threw me off, because Facebook or anything else, it's not like a website where you would put it on the bottom of every page.
So I believe that, so what happened here in this particular instance, we had, if you will see, a slew of complaints on social media.
On the one-click rules?
And I believe it is one person that says they're a licensee, but we haven't found that information. Basically, that person is anonymous. And they are claiming that the person is advertising their cell phone number on the particular advertisement. And so it was like a posting on the social media, and it had the advertisement, and then it had their cell phone number, but it also had a link to their firm's page.
That was one click away?
Yes, so if you click on that link, then it would take them to the firm page with the correct information.
Okay. Right, I move to dismiss number 53.
Motion by Ms. Frank, seconded by Mr. Moffett to dismiss. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Number 55.
55, I think, was where the agents maybe they were using designations that in their advertisement, and just the question was, it says maybe in the second paragraph, are not aware of any outstanding invoices for the designations. I mean, were we able to verify that they do have these designations? And
I was, when I looked it up on the internet, they do have these designations, and also for the sake of this, just because of the complaint, they have removed that from all other of their listing information as well. But
to know if they had a designation, you'd have to log into whatever that
you have to
designation
go to each
is.
designation.
Oh, well, I wasn't able to do that, but
Yeah.
I don't have access to that information. But I do know that since then, they have taken off the designations, but I don't have any evidence to suggest that they did not use them.
Well, by the fact they took it down leads me to believe they didn't have the right to do them.
Well, they didn't admit that they did it. They said they took it down in an abundance of caution. So I don't know how I would be able to verify it.
It's usually pretty easy. I mean, if like they have a CRS, you can go to Certified Residential Specialist, and it has right there, and you can look in Tennessee and what city, and it tells you who it is. It's not hard.
And those things are really, really important to realtors, because you spend a lot of money getting those designations, and it sets you apart because you have those designations. It's like a CCIM. If you're not, then you shouldn't be saying that, because it gives you credibility where you wouldn't have otherwise. So I can see how someone would consider that as false advertising.
Where a lot of those designations are different you got to keep renewing them every year to keep them. It's not like your high school diploma. Once you got it, you got it.
And if they were true, I wouldn't have taken them down.
Oh, I'd say I'm right, and here, look on my site, and I wouldn't just say, well, didn't know if I didn't pay my invoice. Only one, don't look up if they're a GRI. GRI, they don't have to pay anything. You need time to look at that, we can go on
Yeah, I'll
something
look
else.
at that one just
Okay.
to, I'll have Caitlin look it up.
Okay, let's go to 56.
Then I had 56. I was just confused. I just didn't really understand what was.
Okay.
Apparently, no one else had the same.
So what happened with this complaint was, complainant states that the respondent did not inform them of an easement that was running on their property during the sale or the transaction. Respondent stated initially when they checked the MLS tax suite and then a geographic information system based on where they're from, that information was not provided to them. It was only after another party pulled the original parcel information that the easement was discovered. None of the parties knew about the easement, but ultimately in the transaction, when they signed off on it, they had the original deed that listed the easement. So I guess they're in the property, it closed in either way.
But here's what happens. Had a closing yesterday. Here's the deed, son, right here. Okay. Here's the, and that's really how it happens. And maybe you don't know until you, afterwards, and you read all the paperwork. And an easement wouldn't necessarily be on the geographical information from Real Tracks. It all depends,
You probably got to go back to maybe either where either the deed or the plat, and they'll be recorded on the plat.
Or the title policy.
Yeah. No.
So my understanding is when we've had similar discussions before, it goes to whether how far an agent is required to go and look for that information. And I thought based upon this that they did do their research. There's the person that owned the home didn't know about the easement, and it was only after a third party did more extensive research that they found out about it.
And you don't usually go and do that kind of research. Do you read title policies before you have closings?
No,
We look for the
not some
title
kind of
companies to find those errors.
Yeah.
And they'll call you beforehand.
I'm going to make the motion to accept council's recommendation to dismiss.
Second.
Motion by Mr. Wood, second by Ms. Franks, that case 56 be dismissed per council's recommendation. Those in favor of that motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. We're back to 55.
55?
Or if she's looking, go
I
ahead.
have a question. Well, I can go ahead and do number 4 if you want to
Yeah,
wait.
let's do that.
Okay, so I looked in here and they did not upload any specific listing agreements. I'm thinking because the complainant didn't identify any specific listings, but they provided an email from one of their sellers for the house that they renovated and then sold. And it's confirming that they had a listing, but what the complainant is talking about is when they're on social media and they post the home as it's being renovated, not necessarily when it's posting it to the MLS and advertising it that way, but just saying, oh, we're renovating this home, we're going to do this and that to it, and showing the progression of the renovation. And then after that happens, they're ready to put it up on the MLS, but before they put it up, they're getting all these people contacting them and saying, oh, this looks like it's going to be a great home. When is it going live? I'm interested. And they're like, well, it's not listed yet, but as soon as we get it listed, we'll let you know, and you can make your offers that way. So I didn't think they were doing anything wrong by posting on social media and showing the progression of the renovations, which is why I recommended the dismissal. But I'm curious to hear your thoughts about them posting to social media and showing the renovations when they do have an additional business where they're doing those renovations. Like, I didn't think there's anything wrong with that. I could see how it could appear like they're doing some advertising.
But the question is, did they have a listing agreement?
After the fact, after they finish renovating it?
Well, when they put the coming soon sign out, they have to have a listing signed.
So this is what I'm saying. When they say coming soon, and it's like when they're talking about the renovation is going to be complete and the home will be complete, and that's coming soon, and they put that on social media, they need a listing at that point. And it's
no,
not
they need the listing when they put the sign in the yard.
Yes. So it wasn't a sign in the yard.
They need a listing if they put it on
if they're
Facebook,
marketing the property,
anywhere.
They need to have something in writing.
It's marketing.
So, and that's kind of where my confusion is, which is why I want to talk about it. So if they're on social media, they're talking about an unrelated business, and they're advertising the renovation, and they're saying, well, this home will be coming soon as a newly renovated home, that would qualify as an advertisement.
That's the reason they're putting it on there.
Yeah. I would just say, maybe you could just reach out to the respondent and just say, can you send us a copy of the listing agreement?
And just look at the dates and see.
The dates will tell you.
Okay,
Yeah.
I can do that.
You're saying the person that owned the home and renovated the home is the realtor?
So the realtor is not the person who owned the home. They're a husband and wife team. So the husband has the renovation company, and then I'm thinking the wife is the actual realtor. And so the husband, I don't know if I don't feel that they needed a listing agreement to do that.
Advertise they do.
But I don't look at it as them advertising to sell the home.
Did you not say it was coming soon?
But
That's what that means.
I know, but the way that they posted it, it could be interpreted that they meant a newly renovated home is coming soon, like the renovations will be finished soon, not necessarily, oh, I'm trying to sell this house.
But
I don't know if that makes sense, but I think there's some gray area there, so I wouldn't recommend discipline unless we
See,
get this.
I didn't get the feeling that the agent or their spouse owned it. I thought it just said.
No, they don't own it.
Okay.
No.
Okay.
You got a contractor, and he's
Yeah.
doing the remodeling, and so
Yeah.
she wants to put an ad on
Yeah.
Facebook
Yeah.
and says, and if you want to buy this, it's coming soon.
Yeah.
That's
If you could just
advertising.
reach out and get a copy of the listing agreement.
Yeah.
Then we can make us a good decision.
We'll bring it back
Come
next
back
month.
Next month.
Yeah.
All right, we've got one, what was the 55 designations?
Go ahead. 55, it appears from my search that I cannot find the individual with the designation. So if that is the case, I would still recommend a dismissal against the real estate firm, but to open complaints against the individual brokers.
Yes.
Can we accept council's recommendation to do that then?
Second.
All right, the motion on the floor, made by Mr. Wood and seconded by Ms. Franks, is to dismiss the case that is in front of us, case 55, and at the same time open administratively a case against the affiliate broker referenced in the previous case. Let's vote. Those in favor of that motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. So to be clear, 56 is coming back to us next month. Is that right, Kristen? Number 4. 4, I'm sorry. My fault. That's why I wanted to be clear. All right. I'm going to bring up lunch again.
We will work expeditiously if you would like us to.
Expeditiously.
You got it, Anita.
And if you want us to summarize the complaints instead of reading them all, we can also do that.
See what commission's pleasure is as we go through this. Sometimes it's commission that needs to work expeditiously.
Right, I understand.
No, you wanted to say, we know that.
It all depends if everybody read the cases.
Yep. All right, let's go, Kristen.
I just think for future reference, Real Estate Commission needs to get off their checkbook and bring pizza in here. I just want to point that out. Let's go.
Let's go. Number
All
one.
right. So you guys want summaries then, not
Not
for-
yet. This is a short one.
Okay. All right. Number one, 2019-084911. Complainant is an anonymous individual. Respondent is a real estate licensee. Complainant alleges that respondent is engaging in unlicensed activity. Complainant alleges that respondent is meeting individuals in a public storefront rather than a private office. Complainant alleges that respondent is advertising this public storefront as their office and meeting with clients there. Complainant states that respondent is not a licensed principal broker and does not have the authority to run a firm under their license. Complainant further alleges that the respondent's firm is not registered with the commission. Complainant attached a copy of the respondent's Facebook page, which advertises the firm. The respondent filed a response stating that they do not run a brokerage. They rented a private office space, but they no longer have that workspace. Respondent states that there is no signage to indicate that the space is operating as a firm and that it is used as a respondent's private office. Respondent states that before they started a team, they had a private Facebook page that included their workspace address, and they forgot to delete the address from the Facebook page when they started a team. Respondent states that they work for a firm under a licensed principal broker who has obtained a firm license. Respondent attached pictures of the workspace. No signage appears on the location to indicate that it operates as a real estate firm. My recommendation was a letter of warning regarding Rule 12600241-1, which prohibits licensees who hold themselves out as a team from establishing a physical location for that team that is separate from the physical location of record of the firm with which they're affiliated. I think definitely was an oversight for this person, but they did have that private workspace on their Facebook page, and that can be a bit misleading. So I thought because they didn't have any prior issues with the commission that maybe a letter of warning would be appropriate since they have corrected the issue at this point.
So they're no longer in a building outside of where the firm is located?
Right. They don't have that workspace anymore.
Okay, so how long do they have that workspace?
I'm not sure. I know it had to have been since the complaint was filed, which was, let me see, just a few months ago.
10/13/2019.
Oh, it was at least
October.
since then.
It was since the rule was passed, right? I mean, they were clearly in violation. This is a big issue.
Huge issue.
Yes, I agree. So I do think discipline is warranted. It just depends on whether you all agree with the letter of warning or something different.
Honestly, I had to call Anna because I thought it was, could have been one of several that I knew about. I'm just glad I'm not the police, so I don't have to turn people in. But this is pretty rampant. As teams get bigger, they need their own space. A lot of companies are downsizing, getting a little smaller because everything's on the internet. But it's kind of a rampant issue. I don't know. What do y'all think? Is a letter of warning enough?
This person is not a principal broker, but they are a licensed broker.
Oh, I know. So
And
they should have known better.
Yes, I agree. However, they've not had any discipline in the past. I've not run across this person's name at any other time, and I think that it was just an oversight, which is not an excuse, but I think a letter of warning might be more appropriate in this circumstance.
Whenever there's a team, it's two or more people. So, and this person actually put in jeopardy these other people too that are in that office with her. That worries me too.
Well, my inclination would be to go after the principal broker who allowed this to happen. I mean,
Bad as I hate
Go,
to
Steve.
say it.
What would your letter of warning state? If you did it again, what would happen?
So further formal discipline could occur, a civil penalty, CE, things like that. I mean, that's the most that we can.
So, because you're new, I'll just explain kind of the discipline levels. So we have letters of instruction. That is not considered formal discipline. It won't show up on the disciplinary action report. We also have letter of warning, which also won't show up on the disciplinary action report, but is considered private discipline. So letter of warning, we state in the letter that this does not count as discipline upon your license, but it will be considered in the future if another complaint were filed against you. So if you look on the history, you'll see letters of warning show up as you would see a consent order or an agreed order. So what we usually do is just inform them of the violation and give them the specific rules and statutes and tell them next time this will be considered if we have another issue.
I'd like to make a motion. I'd like to accept council's recommendation, and I'd also like for us to open up a complaint with the principal broker. Anybody?
All right. Thank you, Mr. Moffett. Made by Ms. Frank, seconded by Mr. Moffett. We're going to accept council's recommendation if this passes and also open administratively a complaint against the principal broker.
Don't you think this agent has some responsibility? I mean, other than just letter of warning?
Well,
You can make an amendment. I'm happy for you to.
I'll make an amendment that we'll have a $500 civil penalty on this person and also open a complaint against the broker.
all right. Anyone want to second?
Second.
Ms. Franks does want to second Mr. Wood's amendment. Is there any reason, Mr. Moffett, why you wouldn't go along with this? You okay with it?
He's good.
I'm fine.
Okay, just want to make sure.
Fine.
All right, the motion is to offer a $500 civil penalty to the licensee and at the same time open administratively a complaint against the principal broker. That's what's in front of us. You ready to vote? Those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. All right, now, can you summarize, I know it's a short paragraph, but you,
Number 2, 2019-085021. This complaint was opened administratively. It's regarding trust money and the delays that were created.
Move to accept council's recommendation.
Second.
motion by Ms. Frank, seconded by Mr. Wood. Council's recommendation be adopted and the licensee be offered a civil penalty of $250. I'm sorry, the real estate firm be offered a civil penalty of $250. Is that the right place to do this with, or is it principal broker we want to deal with?
It's firm. Okay. You're right. It shouldn't have been.
First time today.
Okay, so can I take back my motion
You
then?
can withdraw it at any time.
I'll
before we
withdraw
vote.
my motion and I'll supplement with this. I will supplement with this that we dismiss as to the real estate firm, but we open a complaint against the principal broker.
Is there a second?
Second.
Thank you, Mr. Wood. Discussion. If this motion passes, the firm will be off the hook, but a complaint will be opened against the principal broker. Let's vote. Those in favor of that motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Number 3, Ms. Downey.
1 second. Okay, so since you all have dismissed and opened against the principal broker for this one, we're going to do that for 3, 4, and 5 also.
Okay.
Just amend.
These were all done administratively, so in the future, when you do it administratively, if it would be against the principal broker, because that's who's responsible for the earnest money, not the firm.
Got it.
All right, is there a motion
So
to dismiss cases 3, 4, and 5, and in each case open an administrative complaint against the principal broker?
So moved.
Ms. Franks made the motion. Mr. Moffett seconded that motion. Is there discussion? Let's vote. Those in favor, vote aye. Aye. Those opposed, no. Those three cases are handled. Number 6.
Number 6 is 2019-085091. This is also, well, I guess number 6 also would be included in this, but this is about property management monies.
Is that what
So-
PMI is in here?
Yes, and it's a commingling of funds issue, so
I wonder why it was private mortgage insurance.
I was too. I was trying to figure that out.
I don't know. That's what they have in the complaint.
So your recommendation at this point is to dismiss this complaint and open a complaint against the principal broker?
Correct.
So moved.
Ms. Franks makes that motion.
Second.
Mr. Woods seconds the motion. Discussion. Those in favor of that motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Number 7.
Okay. Number 7 is 2019-085441. Do you guys want to?
Why don't you give us a summary on this
Okay.
one?
Let me just look at it really, really quick. Okay, so this is basically an issue where there was the complainant had an offer on the home, but it was contingent on the sale of the property or their property, and they had a first right of refusal. However, the respondent continued to market the home, and because they were continuing to market, they received an additional offer. As a result, the complainant was upset by this because they felt that you don't get to continue to market the property if I have the first right of refusal on the property.
Complainant, yeah, the complainant wanted it made pending and to stop showings.
What's your motion?
So-
Motion to dismiss.
Is there a second?
Okay.
Second.
Motion by Mr. Woods, seconded by Ms. Franks, that this complaint be dismissed. Those in favor of the motion, vote aye. Aye. Those opposed, no. The motion passes unanimously. Number 8.
Number 8 is 2019-085401. This is another advertising complaint. As you can see here, the complainant states that on their, I guess, email footer, they have an advertisement where it includes the firm name, the licensee's name, the firm name, and then the name of the LLC, but it doesn't have the firm's telephone number in that footer, which even though it's an email footer, it's still considered an advertisement, and you're supposed to have your firm license.
All right, Commissioners.
I'll move to accept council's recommendation.
Second.
Mr. Wood makes a motion to accept council's recommendation. Mr. Moffett seconds it. Here's my only question. It seems to me on first-time advertising violations, we've been hitting them up for $500, not $250.
Would you like to amend?
I wouldn't.
Well, and John, I'll tell you this, I've threatened to do this, and when I teach a class, I've always wanted to say, quick, everybody just send me an email real quick, and then look at them and go, every stinking one of y'all guilty. You know, because I think it's one of those things, people don't know
They
about
don't know
this.
it.
They do not know this, and so that's why I was thinking 250 rather than 500. So, because I think we can, if we really need to raise a lot of money in real estate commission, we can pop about everybody if we want to on this one, so.
All right, so the motion, mine was just a rhetorical question at this point. The motion is to accept council's recommendation and offer a $250 civil penalty. If you're in favor of that motion, please vote aye.
Aye.
If you're opposed, vote no. The motion passes unanimously. Number 9.
2019-086321. This is an individual that has come before us in the past regarding this property management company where the person has basically disappeared and has taken money, thousands and thousands of dollars from their clients, and we've not been able to locate this person. And we've already referred the cases to the district attorney because it's not anything else that we can do. So what we've decided is we're just going to continue to close and flag these cases in the event that we get a lead on this individual, but they already have an expired license, and we've been getting some conflicting information about whether this person is even still alive. So at this point, it's best to just let the DA do their job, and then.
So why did it come back to us then, if we sent it to the DA?
Well, this is a different, people just keep filing complaints. It's more and more people that keep coming up that this person has done this.
Move to accept council's recommendation,
Second.
close on flag.
Motion by Mr. Wood, second by Ms. Frank, the council's,
Close
Ms.
as well.
Frank's, council's recommendation be adopted, and this case be closed and flag. If you're in favor of that motion, vote aye.
Aye.
If you're opposed, vote no. The chair will recuse me. Okay? Number 10.
Number 10, we're going to defer this complaint to the next legal report. It won't cause any problems in terms of us keeping our numbers together, but I would like to get more information on this person's indictment and just the status of the trial, and I would rather just wait since we have the time to wait.
Objection. Looking forward to you reading in the first couple of sentences, but.
I bet you were.
I just.
So are we deferring it then?
Yep,
Yes,
till-
ma'am.
Till April.
Do we need a vote for deferring?
Without objection. Let's
Okay,
move on.
that's fine.
Number 11, looks like a good one to summarize.
Somebody's got to get to East Tennessee.
Let me look at it really quickly, and I'll give you a quick summary. Okay, so number 11 is 2019-089691. So this respondent basically had two offers. This person accepted an offer and was still negotiating another offer and had not communicated with the second person that their offer would need to be a backup offer. They had this letter where they could sign and they would know that this would be considered a backup offer if the first offer falls through. However, the respondent did not get the letter signed and never sent it. They thought they did, but they did not. And they didn't
I think the person sold the house twice, is what ended up happening.
Yes, that's essentially what
So-
happened. But because they did have that form where it seemed to me that they did understand that was a possibility and didn't want it to be a situation where they sold the house twice, I think assessing a civil penalty might not be the best option. It sounds like this person maybe just needs to get some education to make sure they're looking over their contracts properly, understanding what they say. So I recommended a 4 hours of CE and contracts.
Based upon what our E&O company was telling us this morning, this is the biggest number thing. I mean, so my thought is, I'll make the motion.
Can we talk about it in a minute?
Okay.
You make a motion, let's get a motion on the floor.
Okay. My motion is for a $1,000 civil penalty and 4 hours of CE, has to do with contracts, is done within 180 days. It doesn't count toward their continuing education.
Is there a second to that motion?
I'll second it.
Thank you, Ms.
But I'd
Franks. You
also
have the
like to
floor.
add, I'm finding fault with the principal broker here for lack of supervision.
Okay. But we'd have to open another
I know,
complaint.
that's what I'm saying. What do you feel, how you feel about that?
I'm fine with that.
Because it's serious, this is serious.
Yeah.
All right.
All right, so we're going to have a second motion following a vote.
Okay.
Vote is on case number 11. Motion offered by Mr. Wood would offer this licensee a $1,000 civil penalty as well as 4 hours of education requirement with our standard conditions applied. If you're in favor of that motion, please vote aye.
Aye.
If you're opposed, vote no. The motion passes unanimously. Number 12, is this similar to one?
Well, are we not,
Oh, I'm sorry. Yeah. My
Principal
fault.
broker.
Excuse me. Ms. Franks offered a motion that we would open a case against the principal broker for failure to supervise.
For number 11.
Yes.
Yes, ma'am. It's related to number 11, and Mr. Wood seconded that motion. Let's vote on that. If you're in favor of that, vote aye.
Aye.
If you're opposed, vote no. That motion passed unanimously. Number 12, same as number 9?
Slightly different.
Okay.
It's different because the home wasn't actually sold. Well, it's about a listing agreement essentially. And let me read the complaint number.
Sure.
2019-09-1301. So basically what happened, there were two licensees who were working with this seller to try to get their home sold. Well, the sellers felt that they weren't doing enough to get the home sold. So they go to this other licensee who's the respondent, not affiliated with the complainant's firm at all, but they go to the respondent asking them about, what they can do to get their home sold. At this point, the respondent isn't entering in any agreement with them, but just basically listening to their grievances. Well, the sellers become very sad, they're crying on the phone, so they ask the respondent to send a letter, the mutual release to the complainant, a signed mutual release. So the respondent does this for them and then enters into a listing agreement with the sellers. Problem is that there was an existing listing agreement with the complainants and it did not expire until this past January. So the respondent is saying that they thought that it was terminated because the RealTrack status was updated. However, to me, it seems that just having the RealTracks updated and withdrawing the listing from the original complainants doesn't necessarily mean that the listing agreement was terminated. So I recommended that I would recommend that we issue a letter of warning to this person because it appears that they weren't trying to be malicious in this, but they thought that something that did not count as a mutual release was a mutual release. So that's essentially the gist of the complaint.
What was the RealTrax change?
To withdraw from the MLS.
That's the real question. If you withdraw from MLS, does that void the listing
Right,
agreement?
that doesn't count as a mutual release, right?
It's two separate things.
Right, and so I had another complaint like this where they withdrew, but they also had a mutual release where they were going their separate ways, so the listing agreement was no longer in effect. But this is not the same situation, but because they came up where this individual thought it was the same, I thought it was important to discuss it and just make sure individuals know that a RealTrack status change is not the same as a mutual release.
And I hold them to a higher standard because they're a broker and they have 38 years of experience. But then that also goes to they probably have had no education because they were grandfathered. So this person should really know better.
All right, so is there a motion to accept council's recommendation?
Well, it's just to discuss.
Well, my recommendation
No, she
is
made it.
essentially to issue a letter of warning regarding those particular issues we talked about. However, I did want it clear that those two things are not the same, but I do have a recommendation to issue a letter of warning.
And does that letter also go to the principal broker?
Doesn't become.
But we could send it to the principal broker, but it won't show up on their license. Like, we could address it.
That's fine, but I think the principal broker needs to know.
We could address it to both parties.
Yeah, that would be great. That would be my motion.
I can do that.
Seconded by Mr. Moffett. So we're going to send a letter of warning, a duplicate letter of warning to both the principal broker and the licensee.
Yes.
If this passes, let's vote. If you're in favor of that, please vote aye.
Aye.
If you're opposed, vote no. That motion passes.
And I recuse myself on that one.
And as a matter of fact, I do too. Come to think about it, I do recuse myself.
And
This isn't the one where you had to recuse yourself, or did you?
I thought Ms. Matlock told me 9 and
Is it
12.
12? Is it
9 and 12 is.
20.
20, not 12.
I vote aye.
and don't put RealTrax in there because that tells us where the location is.
I know that.
Yeah.
Okay, thank you. Are you all ready to move on?
Yeah, we're ready to move on, aren't we, John?
Yes, we're ready.
Number 13.
More than ready.
All right, number 13 is 2019-095791. This complaint is essentially about the construction of their
Move to accept
home.
council's recommendation.
Thank you.
Seconded by Mr. Moffett. Discussion. Those in favor of the motion vote aye. Aye. Opposed, no. That motion passes unanimously. 14.
Number 14
2019-097561. I will summarize this one. Oh.
It had to do with the earnest money.
Yes, okay, so we've had this one before, but it was against the affiliate broker. So we dismissed it against the affiliate broker and opened it against the principal broker. So they basically terminated the listing agreement and had a mutual release signed. The complainant didn't get their earnest money back for several weeks. However, looking at the file, it looks, I have no way of proving this, which is why my recommendation is a letter of warning, but it looks like they tried to submit the earnest money check to this person without using certified mail. So you can't really track where it is or where it went. So I can't say for sure whether the respondent actually sent it timely, but the only thing I had in the file that created a timeline was an email from the affiliate broker that had a timestamp of June 12th when the check had been sent. And so because there is that gray area of me not knowing whether it was sent earlier or if it was sent past the 21-day deadline, I think a letter of warning is more appropriate for the principal broker than actual formal discipline.
So it was 9 days more than what it should have been?
Correct.
Well, but it has to do, it's not, you got to go by the date in which they asked for the money.
Yes.
It's not when the deal died, because sometimes we keep trying to work deals out and stuff. That's why I'm not so sure. This might be more of a letter of instruction, because a warning is a ding on them, right?
Well, I mean, neither one of them count as formal discipline, but if you do feel like...
Just letters of instructions won't show up on a disciplinary history if you were to request
Based upon this, I can't rightly say they did something wrong. And so my motion would be just a letter of instruction.
Okay. I think that's
Second.
Mr. Wood makes a motion that this licensee be sent a letter of instruction, this principal broker, actually, right? Yeah, principal
Right.
broker, seconded by Ms. Franks. Discussion, let's vote. Those in favor of that motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Number 15.
All right, number 15 is 2019-09-8491. This is a situation where the complainant bought a property that was listed as a property that had public sewer and a two-car garage. Well, it turns out...
I make the motion that we accept council's recommendation to dismiss it against the firm and open it against the listing agent.
Okay.
You've heard the motion. The second was by Mr. Moffett after the motion was made by Mr. Wood. Discussion, let's vote. Those in favor of the motion, vote aye. Aye. Those opposed, no. The motion passes unanimously. 16, represent.
All right, number 16 is 2018-09-0951. Okay, so the new information is that council contacted the respondent to ask about the status of the litigation, and the respondent stated there was no litigation that was ever filed, and their license is now inactive. My new recommendation is a letter of warning. Well, if they have inactive status, we can't issue anything. We can still, okay. So my recommendation is a letter of warning regarding reasonable skill and care.
What did they do wrong? I struggled with that.
So they, hold on. This wasn't originally mine, so give me one.
They had an inactive license.
Well, that's not what the issue was. Prior, when this was presented.
I think they were
it was
property
about
managing
the-
them.
It was
and
something about
then they
the-
sold them a house, and then the buyer said they charged them too much commission or something.
That's right. It's about the commission, and they thought they had a carryover clause in the contract, but they did not. So that oversight pretty much shows that they weren't really careful in the transaction, which is why I recommended the letter of warning for reasonable skill and care.
Move to accept council's recommendation.
A motion by Ms. Frank, seconded by Ms. Torbett to accept council's recommendation. My only question on this has to do, why did we think it was in litigation?
I think the attorney who had it before spoke with them, and they told them they filed a lawsuit, but then once the follow-up happened, they actually did not file it.
Who do you think the attorney talked to? I know it's hard for you to tell me. Was it the respondent or complainant?
I have no idea.
That's the problem with this case at this point. Let's vote on the motion, which is to accept council's recommendation. Those in favor of that motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. 17.
Okay, so number 17 is 2019-070921. We've had this one before, obviously, and the new information is that I spoke to the respondent regarding their failure to indicate whether the seller accepted, rejected, or countered the buyer's offer. And when I spoke to this person, they essentially said that they didn't hit accept, counter, or decline, but it was because they talked to their client, and their client was supposed to check the boxes through Dotloop, and the client was confused on how it worked, so they weren't able to check the right box because they didn't know how to figure it out. Well, the respondent talked to the complainant and explained the situation, and the complainant was like, oh, okay, understood, no big deal. But then after the transaction was over, the complainant made these complaints about not having the boxes checked. And she did, or this respondent did give me an email where they actually talked to the complainant and said, I know that what it looks like, but I'm trying to fix it. But she gave them both access at the same time. So before she could fix it, the complainant saw it. So I don't think this was a situation where they were being careless. So my new recommendation is to dismiss.
So we had new information after we'd offered the consent agreement. Why would the respondent not have included that information in his or her initial reply?
I don't.
I mean, sometimes it just seems like we don't get someone's attention until after we say there could be a financial penalty involved. And then they start thinking about the response or coming up with a response that fits the narrative that's already been presented.
So the principal broker would have gotten a letter also, right?
I think that it's not that they didn't include the information, it's just speaking with this person just kind of clarified things, because they did provide me with a copy that had the actual checked boxes after the fact, but when they initially sent the information through Dotloop, it wasn't checked at all. And so the complainant only sent me where they asked, hey, what's going on? Why isn't this checked? But didn't send me the response from the respondent. So they did, before the transaction closed, they had the boxes checked, obviously. Just didn't give me all the materials.
Well, they changed the contract after the contract was final.
No, I think the complainant sent me what they saw when it was in real time, and both parties had access to check the boxes. And the respondent didn't have enough time at the moment to correct the issue, and the complainant just painted it in a light where it wasn't completely honest.
Did it close?
Yes.
Okay. I move to accept council's recommendation to dismiss.
Second.
Motion by Ms. Frank, seconded by Mr. Gwynn, that council's recommendation be adopted and this complaint be dismissed. Those in favor of that motion, vote aye. Aye. Those opposed, no. That motion passes unanimously. Thank you, Kristen.
Thank you.
Ms. Madlock, let's see how you can do on this.
I'm confident. Just fine. Number 18 is 2019-08-9981. Would you like me to read it? Or
I'd like for you to be as succinct as possible.
Okay. So this is a complaint against an expired real estate firm that they were operating unlicensed. They responded and stated that they had not renewed their license and they need to do so immediately. They have not done that. They've been unlicensed for 3 years, and they have 2 unlicensed agents. So my recommendation is a $3,000 civil penalty for unlicensed activity and administratively opening complaints against the 2 unlicensed agents.
Why don't we just shut them down?
Yeah, why don't we just revoke
I mean, they've been operating close to 4 years now legally.
without a license?
It's expired license, right?
Their license is expired, so I mean, the thing is, if they would have to, I could offer them to voluntarily surrender their firm license. But I'm not
It's
sure.
expired, so I mean, there's no point to that even, is there?
Right, so.
So
It's-
really, it's unlicensed activity at this point.
Yes, so they're not licensed at this point, so it would be unlicensed, so I don't think we can revoke an expired license, which is why I assessed a civil penalty.
When was the last time you checked and you knew that company was still running, though, even without the firm?
So the respondent said in their answer that they are still running their firm at this time and that they needed to change and update their information, but we don't have that. So as of when the response was submitted, so last year, which is why I placed it from 2016 to 2019, the 3 years.
Sounds like we need a cease and desist, we need a district attorney, and we need to file charges against the 2 unlicensed agents. We know they're unlicensed, yes, because they're not at a firm.
Yes, I checked their licenses are also expired.
So the principal broker is expired also?
Everyone is expired.
Everyone's expired.
I've got a,
That's when the complaint was open?
So,
why have we not turned this over to the DA or
attorney.
whoever? I mean, this is,
We can refer it to the district attorney's office.
here's the downside to it. I don't care who the DA is, he's got murders, rape, child abuse, kidnapping, methamphetamine issues, and anything we send to a local DA hits the bottom of the stack. I understand the concept, but I also understand the reality is that they're probably not going to be able to get to it. They got too many other things.
what else do we do then?
Well, we can offer them these civil penalties that are recommended, and, I mean, at least we can
Can
start
we not call
there.
the police? 911 them?
I don't think this is a life or death situation.
It sounds pretty criminal to me.
How did you come up with 3,000?
For the
For
3
each
years,
year.
since their license has been expired since
But,
2016.
I would like to do it,
25 grand.
I would like to do it per transaction that they've had in the last 3 years. We can do it per transaction, and we can do it per day.
We can do whatever we want to.
Strongly discourage. I don't have the transaction number. I would per day. That it is available.
You're doing per year,
Which is I'm doing per year. Per day is
available.
a little bit more than that. It would be in the millions.
Almost a million, maybe just slightly over.
It needs to be a big number, though. I mean, and we need to, I don't care, send it to the DA, do all of these things, because they're still operating today, I bet.
So what we have, what's available to us, we are allowed to, the civil penalty ranges from 0 to per instance. And right here, I only have evidence of, which is why my recommendation was $3,000. Do the civil penalty and also refer it to the DA. Those do not have to be separated.
Let's do this. Why don't you make a motion to accept council's
Okay,
recommendation?
I make a motion to accept council's recommendation as presented.
Is there a second to the motion? Okay, Mr. Moffett seconds the motion now. Is there discussion or
I would like to
amendments?
add refer it to the district attorney in that county also.
Is there a second to adding that amendment?
I think the number's too low.
Well, it's okay. I just want to make sure we know what we're talking about. Can I get a second to Ms. Franks?
Second.
Okay, so what's in front of us right now is a motion to accept council's recommendation to offer a $3,000 civil penalty, open a case against 2 unlicensed agents, and refer the firm to the district attorney, whichever one is appropriate. Now, Mr. Gwynn, you have the floor.
Yes, I'd like to amend it and increase the 3,000 to 15,000.
We have to have some rationale. That's the. So quarterly, you want to do it quarterly instead of
No,
annually?
if she was at 1,000 a year, I'm at 5,000 a year. That's my
we
rationale.
can't do 5,000 a year. So I'd just like to point out the rules for civil penalties. If you have, do you have the green book?
Yeah.
What page?
So if you, or the red book, it'll probably be very similar. It's on page 85 or 84, I would assume. It outlines civil penalties, and you'll see the range is from $250 to $1,000.
93. It's
93.
It's 93.
For
93 in
each
the red
separate
book.
violation.
Correct. So
So they violate it every day.
I think we could make that argument. I think the big thing is we're trying to get this thing corrected. I mean,
Right, and then-
they might come closer to correcting it over 3,000 if we send it, I mean.
They're not gonna pay
and-
anything.
And what
We're not
little.
going to pay anything.
Yeah,
That's right.
yeah, that's right.
It doesn't matter what the number
so I
is,
would-
but I think a bigger
Yeah.
number makes.
Oh, Steve, I like you. We're going to fit along good here. But I'm kind of like, throw the 3 and see if we can get the action corrected. I don't think we'll ever see a 20 or any kind of number, but.
You're not gonna see the 3 either.
Yeah, I don't think we'll see the 3 either. I think
Well,
the best thing we can do is shut them down.
It may say something to other people that may be looking at this. It's like, whoa, these guys are serious about this at whatever the number can be.
So how can we define an instance that has happened often enough that we could get to that number? That's going to be difficult.
I think you just need rationale or justification, and you might want to make it $1,000 a quarter for 3 years and 1 month.
Does that get me to?
3 years and 3 months. Just, you have to have
Let's see,
some
1,000
rational.
for that. Okay.
That can get you to 15,000 pretty quickly.
1,000 a quarter for 4 years. That's 16. All right.
I couldn't hear you, Anna.
They're not gonna they're not
Right,
gonna
I
sue
understand,
us.
but I don't think that, I don't think that is a rational number for what we have here. And also in the complaint, we only had 3 listings as well. So I don't see where defining it by quarter, like splitting a year into quarters, like you can do a civil penalty per day, but it's not encouraged to do so, because you need to look at I would look at the factors that are listed in number 4 to see if you think $16,000 or $15,000 amounts to that. And I don't think $16,000 based on split into quarters is in the best interest.
When did they respond to say that they were going to renew their license?
They responded, I can check the official date, but I know it was in 2019.
They got notice probably somewhere in November.
November of 2019.
And they're still not.
And they're still not licensed.
They're not licensed.
It ain't happening.
So I'm going to, at this point, say the motion that has been, an attempt has been made to amend the motion on the floor and take the civil penalty to $16,000. Is there a second to that attempted amendment?
Second.
All right, now on the floor is a motion as amended that would offer a $16,000 civil penalty and also at the same time open 2 complaints against those unlicensed folks associated with this firm. That's what's in front of us. Is there discussion on the motion? All right, we're going to vote on the motion as I just stated it. If you're in favor of that, offering a $16,000 civil penalty, please vote aye.
Aye.
If you're opposed, vote no.
No.
Chair votes no. Ms. Torbett votes no. Mr. Bagley votes no. The motion passes on a 4-3 vote. Number 19.
2019-093251. So this is an advertising violation complaint, and the respondent's sign is in violation. This firm name is not the same size or bigger than the team name, so I recommend a $500 civil penalty.
Move to accept council's recommendation.
Second.
Mr. Wood makes the motion to accept council's recommendation. Ms. Frank seconds that motion. Let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Number 20, which I'm going to recuse myself on.
Number 20 is the same complainant from respondent from number 9. It's another complaint regarding the respondent not remitting $11,000. Or recommend that since we're unable to locate respondent, to close and flag and refer this to the appropriate DA's office.
Move to accept council's recommendation.
Second. Mr. Wood makes a motion. Mr. Moffett seconds to accept council's recommendation. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. 21.
2019-094241. This is an earnest money complaint. So the complainant is alleging that the $500 deposit was not returned, and they eventually closed, but and this complaint was originally opened against the respondent's affiliate broker, but the commission recommended that we open this against the principal broker since they're responsible for disbursement and maintenance of escrow funds. The principal broker responded to the complaint and said that their law office at the time was still processing the transaction, and that they were awaiting a death certificate in conjunction with the transaction, and the binding contract date at the time was 3/28/2019. And so basically they're relying upon the fact that they had a reasonable reason to hold the earnest money, but based on the information provided, I believe that reasonably interpreted, the contract authorizes them to hold the trust money, but absent a compelling reason, earnest money shall be dispersed within 21 days, and that was not done here, and I recommend a $500 civil penalty.
But the broker said they made a reasonable interpretation of the contract, isn't that right?
I believe that they said that the respondent never paid the buyer for the surveyor, and
they're still processing it today?
that was at the time of the complaint that was sent in. I think now that it's been closed, I don't believe that the earnest money was, I believe it was returned, but not within the time period. But yes, essentially they were saying it was compelling reason.
And why did they need a death certificate to return earnest money?
I don't know. It had to do with the transaction. One of the parties passed away.
As to who gets the money?
Mm-hmm.
Or who can sign.
Mm-hmm.
And I'm assuming maybe that's the Tennessee Realtor contract?
I can double check, but I'm going to say yes.
Okay. But one of the items on there in that contract, it gives about 5 ways that the earnest money, something can happen to it, and one of them is upon a reasonable interpretation of the agreement. And that says holder shall disperse earnest money, trust money only as follows, and one of those upon a reasonable interpretation of the agreement. So
It was under a Tennessee Realtor form.
okay, I mean, so I don't know that we can, from where we're sitting, go back and say, well, that's not a reasonable interpretation. So a motion would be to dismiss.
I'll take it if I get a second.
Second.
Motion by Mr. Wood, seconded by Ms. Franks, that the complaint number 21 be dismissed. Let's vote. Those in favor of the motion vote aye.
Aye.
Noes vote. There are none. The motion passes 6 aye, no noes. Mr. Moffett was absent for that particular vote.
Oh, you're paying attention.
Hmm?
I said you're paying
No,
attention.
Mason, 22.
Number 22, 2019-095351. So complainant is alleging that the respondent gave their confidential information to, they went behind their back to obtain confidential information that was not privy to them. Respondent states that specifically bank information, they went to the bank to see if they had enough money to pay for the home. And so respondent states that they represented the seller and they contact the complainant concerning the loan letter. and that they did ask the loan officer if the down payment had been verified, and they were told by the loan officer that they couldn't discuss the complainant's loans, and that they were aware of privacy concerns, but it's important that their client had it was a big contingency. The loan officer told them they had a down payment and could easily purchase the home, even though respondent didn't request that information. It was given to them. And then respondent's client then sent a counteroffer and did not hear from the complainant's agent. So respondent provided a copy of the purchase and sale agreement, which does not have the appropriate loan box checked, only a statement that says that they were pre-approved by some bank. And I don't believe that it was a direct violation of any of the rules and statutes, but I think a letter of instruction concerning 6213-4033, which deals with confidentiality with duties to all parties, would be prudent.
I'm assuming the respondent, they were maybe the listing agent? Is that kind of what I'm assuming? That they were representing the other side?
Yes, that's correct.
I don't know that there's anything wrong with asking.
I was kind of torn about this
Yeah.
one. I don't know what is normally done in normal practice, but like looking at the rules, I don't think it's a violation of their confidentiality rules. But if you thought that it would, I would think it would only amount to a letter of instruction.
You don't even usually know what the bank is until they
give you a letter
it to you.
But sometimes you can talk to a lender and they might give you some information, and other times they won't. Usually they'll give you any information that
Yeah.
will help their client.
Yeah.
I would make the motion to dismiss.
Is there a second?
Second.
Mr. Woods makes a motion, Ms. Frank seconds, and the motion is to dismiss. Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously, 6-0.
Number
6-0.
23 is 2019-095751. This is another advertising violation. Ultimately, the respondent said that they mistakenly uploaded the wrong flyer, which should have had the office information.
I'll make the motion to accept council's recommendation.
Second.
Is to accept council's recommendation, offer a $500 civil penalty. If you're in favor of that motion, vote aye.
Aye.
If you're opposed, vote no. The motion passes unanimously. 24.
Number 24, 2019-095771 is another advertising violation where the principal broker contested an agreed citation that was stated. I recommend a $500 civil penalty because on the advertisements, the respondent's last name is not included. And the rules state that your name as licensed with the commission should be provided on the advertisements. And therefore, I recommend a $500 civil penalty.
Move to accept council's recommendation.
Second.
Mr. Quinn, this is the second. I have a question, Anna. So
Yes.
is this a rehear? I mean, did we offer them 1,000 previously and they didn't like it, and so they've come back and now you're saying 500?
So, okay, so there was a $1,000 citation sent because there were 2 violations, but I only found the violation with not having their last name. I do not believe that they were in violation of not having, hold on one second, sorry.
Can you list yourself with the Real Estate Commission with just Marcia?
No.
Or Cher? Or Madonna?
Lefty?
Grease?
Yeah, Grease, that's a good one. Also known as Grice.
Yeah.
So there were 2 violations that were listed here. One was a violation of 6B, which is the firm name and firm telephone number must be listed with the commission. It's the one-click rule, and I think that information was provided in one click, but on the actual advertisement, the person's last name is not included. It's
Okay.
just their first name.
So just one violation?
Yes, so I am amending it to just the one violation.
The motion's on the floor to accept council's recommendation. Let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. 25.
25 is 2019-096311, is another advertising violation Basically, most of the respondents' advertising was incorrect. They answered the complaint saying they recently switched firms and have been in the process of changing their website. But now they have corrected the issue and are in compliance. But according to the records, respondent transferred firms in August of 2019, and this complaint was filed in November of 2019. And so I think that the amount of time period there, they should have had their advertising in compliance. And
Move to
I
accept
recommend-
council's recommendation.
Second?
Mr. Woods makes a motion, Ms. Franks seconds to accept council's recommendation. Discussion, those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Okay, represents.
2000, number 26 is 2019-083631. That is very similar to number 2 or 4 on the previous one. We originally issued a civil penalty for failure to respond. Since Consumer Affairs was separated from the Real Estate Commission, some individuals have been sending their response to just one entity. They had submitted a response, but it did not get to us, and so they've submitted one. I reviewed it, and there's no violations, and therefore I recommend dismissal.
Mr. Bagley makes a motion to accept council's recommendation. Ms. Torbett seconds that motion. Ms. Franks, you have the
So
floor.
how long ago were they separated?
It was around the time that this complaint was open, so the AG's office moved back in around October.
So you're saying that something that was meant for the Real Estate Commission went to,
So oftentimes when we get complaints that are about timeshares, they are cloned by both entities. So it'll go to Consumer Affairs and it'll also go to the Real Estate Commission. And their response only went to Consumer Affairs. It did not also come to us.
and why did they not send it to us?
Well, it was included in the title, it just didn't get here. Like, it was sent to the wrong place.
All right, the motion is to accept council's recommendation and dismiss. If you're in favor of that motion, vote aye.
Aye.
If you're opposed, vote no. That motion passes unanimously. All right, 28 through 30.
Number 27?
27.
And then, but before we do those 28 through 30, let's do 27.
Okay. 2018-067001, new information. We contacted a respondent's attorney to ask about ongoing litigation. All charges have been dismissed, and my recommendation is
Move
dismissal.
to accept council's recommendation to
Ms.
dismiss.
Franks makes a motion to dismiss. Ms. Torbett seconds that motion. Those in favor of the motion vote aye. Those opposed, no. The motion passes unanimously. Now, 28 through 30.
I'll read the numbers into the record. 2018-072661, 2018-079561, 2019-004791. So this was a complaint that was transferred to me. So since dissemination of the consent order and departure of previous counsel, I reached out to respondent and we discussed the issue at length. The respondent had several health and personal circumstances, but recognizes their fault and their lack of compliance. And they would like to avoid a formal hearing if possible. And so, speaking with the respondent, I came with an agreement that I wanted to run by the commission to see if it was acceptable, which would include a 1-year downgrade to affiliate broker license. And then following this year, that respondent would be required to resatisfy requirements in order to apply for their principal broker license. So that means new test, new education, and then a $3,000 civil penalty, and to comply with the new audit within 45 days.
Move to accept council's recommendation.
Second. Ms. Franks makes a motion to accept council's recommendation. Mr. Moffett seconds that motion. Is there discussion on this? I'm surprised. Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. All right, Ms. Matlock, you got a legislative update for us?
Yes, I have 3 bills that I wanted to update you on. First is sunset. It's SB 1684. That's our sunset provision that would extend the Real Estate Commission for 4 years until June 30th, 2020. Next is House Bill 2360. This would amend licensing requirements to include not only a high school diploma or GED, but also the HiSET. That is a new form of someone to obtain the equivalency of a high school education. So
It's like a GED?
it's similar to GED, so it's a high school equivalent.
So is that something online that people can do?
I believe so. I'm not as familiar with it, but I do know that
Never
it is
heard of that.
recent. It is an accepted form, and lots of other people are moving to include this in addition to the GED.
And what's it called?
It's HISET. All of those are in capital letters except the I is lowercase. And then the next is SB 2241 slash HB 2342. This bill would allow a broker that is licensed in another state and does not hold a Tennessee license to enter into a cooperative agreement with an out-of-state broker, so long as that form of cooperation is permitted in the out-of-broker's home state. So the cooperative agreement has to have the material terms of the agreement, including the amount of commissions, effective period, and the property location. The brokers will maintain the agreement for 3 years and provide a copy if requested. The Tennessee licensee is responsible for their own actions and the out-of-state broker's licensee's actions. And earnest money shall be held in escrow by the Tennessee broker unless the buyer and seller both agree otherwise in a written agreement. So if this passes, this would become effective upon becoming law.
Who's the sponsor of that?
Who is the sponsor? I can look it up.
That's okay.
It's not a department bill. It is an outside bill.
I kind of heard that it had been removed or killed in committee, but
I'm not sure where the status of the bill is now, but I was just updating you on this had been filed after our last meeting.
sunset, back to the sunset.
Yes.
What's the sunset date at this point?
Right now, it would be June 30th, 2020, but it would be extended to June 30th, 2024. So it gives us another 4 years.
So right now, we've got about 4 months to maybe 3, right? April, May, June?
No, we don't have to go back again.
No, it's not.
No. But right now, that's what happens. Everyone that's in the 2020 cycle does 2019, so yes.
I just want to make sure. Anything else?
No, other than we are still looking to hire a new attorney, and we will also be hiring a new paralegal as Amanda has left us.
Very disappointed.
So we are, we'll get you updates on those as soon as we can.
All right. Ms. Downey, anything else you'd like to add? That's that right? There is?
It's one thing. Where is my book? Where's my book, guys?
This one right here?
You need to call the Tennessee Realtors Association. That's who gave them to us.
That's the culprit. Okay.
$35 otherwise.
You were supposed to go to the Tennessee Realtors meeting.
I was not invited. What's going on, guys?
We'll see what we can do.
But no, I'm good. Just kidding.
Caitlin, anything on yours?
But I want to know, what are you using if you don't have the red one? Oh, I have the red one. Okay. Scaring me.
No.
Cut us off.
Okay, so you have nothing more to report to us. All right, I want to mention one thing. So there's a real estate school that's, the acronym is TREES.
Yeah.
And the owner of that is a company called, the owner is a fellow who lives in Gatlinburg named Bill Wisner. And he has an instructor who's a licensee in Knoxville whose name is Jennifer Montgomery, and she likes to research things apparently. And so recently, the two of those together sent a newspaper article, the Nashville Tennessean, April 17th, 1921, that talks about the establishment of the Tennessee Real Estate Commission. So a couple things to take away from what I've said already. Next year, then, will be the 100th anniversary of the Tennessee Real Estate Commission, the same year that Ms. Franks will be president of the international organization Arello, which I thought you worked that out pretty good, Marcia. I like how you did that. But he sent a copy of the newspaper article for each of you, and I want to pass those down. And Bill, we appreciate, he's one of our groupies. He listens to most of every one of these shows. Shows is not the right term, meetings.
It's a show sometimes.
Yeah, it is. So anyhow, take that, if you can get a microscope or a magnifying glass. Caitlin made one observation. Listen, quick, your observation about the pen. Listen to this real quick.
I'm trying to remember. My observation was that a lot of the language seemed to still be very similar to violations that we currently see.
So, yeah.
If you can get a magnifying glass. But a lot of the wording is very similar to violations that are current.
Thank you.
And I will say that we did some history work at Arillo, and Tennessee was, I think, the number 4 state in the United States that joined Arillo when we started 90 years ago.
Wow. All right, Commissioners, Joe, anything you'd like to say on the way out? Not a thing. You're sure? Okay. John, anything you want to say?
Everybody have a good week.
Thank you. That's nice. It's much better than what Joe had to say. We appreciate you thinking of us.
Everybody wash your
Yeah, that's what I was looking for. Everybody wash your hands. That's what we want to make sure happens.
Yeah, wash your hands.
Steve, welcome.
Thank you.
We're glad you're here. We appreciate your input and look forward to working with you. Bobby, anything? Yeah.
No, I know he don't watch this stuff, but we appreciated the governor and then the president both coming out to our place and just kind of recognizing the fact that we've gone through in our area, and we're going to be going through for many years. So,
thank you, Bobby. Marcia?
Again, I'll say wash your hands, and I'm actually going to just go out of the country, so I'm not around it. So
Which country are you going to?
Turks and Caicos.
Turks and Caicos.
It's supposed to not be able to live very well in the heat.
Huh?
It's supposed to not be able to live as well,
Well,
in the heat.
The embassy contacted me and said that there are no coronaviruses there at present.
Did they tell you not to bring it?
Maybe I'm taking it, I don't know, since I'm from Williamson
Yeah.
County.
All right, ladies and gentlemen, we are
Thank you,
done. Have a safe
everyone.
trip home.
Thank you.
You sound a little snippy, John. I might have to
I know.
self-quarantine myself
It's-
after being
Stevie
around
did
you.
great
I'm
for a
gonna
first time.
self-quarantine for the
Yep.
week.
In Fort Lauderdale?
We need your wisdom.
Exactly. I hope I didn't make someone's water. There's only one in there, and it was a big one. So
If it's there,
if
drink
somebody
it.
put it in there to keep it cold, I took
did you know
it.
where it was? All right. See you next month. What time is it? In Mount Juliet? Okay.
It is
They say I
1:31.
told them anything bad over there?
Judy got back okay, didn't she?
Oh, well, good.
Okay, good. Looked like a great trip. I know.
The planes are the things that worry me.
Bernie?
I know. I've got my stuff all out to wipe it off. I told